Hey, everybody. If anybody's here yet, got my own stream. Got my own stream. Got my own stream. Hey, Aaron. Oh, I can hear myself again. Got my own stream. Hey, Aaron. Oh, I can hear myself again. Got my own stream. Hey, Aaron. Oh, I can hear myself again. Sorry, just getting everything finalized here. Hey, Lexi. It is a birthday stream for me, so I might have to start drinking halfway through. We'll see how that goes. Great hearing yesterday. Oh, which one? The Melly one? Oh, hey, Matthew. I'm old now. Well, I was old, but I still am old. I used to be old. I am now, but I used to too. Hey, thanks everybody. Ooh, I should check Facebook once a year to see if anyone wished me a happy birthday that I haven't talked to in a long time. How to think of that? Oh, that's right, Ashley. That's right. That's right. I mixed up your names again. That's right. We talked about that. It's my bad. Oh man, yeah, you told me about that. Yeah, that's awesome. I really wanted to cover the Melly thing, but I want to wait until the official stream's in. Oh yeah, hit the like button. I'm still trying to come up with a way to say that that's different. Um, thanks, Big Flip Ray. Yeah, I'm really looking forward to covering the Melly thing. I think they take like a week or so to get the archive up though, so it'll probably be like sometime next week or end of this week maybe. I don't know. Um, so I figured we'd like give people a few minutes to get here in case they're not here already. And while we do that, I thought I'd just start with this case that I found randomly because it's like especially stupid. It has to do with an inmate. This inmate. Oh, you did, Ashley? Drew wasn't there, I don't believe, but I think was it Carrie? I don't know her. I think her name's Carrie, though, right? Um, but yeah, so this case involves an inmate who is doing a life sentence, and he's not appealing that, or I don't think it's life without parole, but it's a life sentence, I believe. And all he's doing is trying to get the Department of Corrections to call him by his actual name. And as you'll see, he's been litigating this issue. All he's trying to do is go by his actual name. It is. It is. This is one of many wrong name cases. I found this while looking for, I don't even remember what. I think it might have been a habeas thing or something. Yeah, it was probably, looking at this, it was probably an appellate issue. Well, we're not going to read through all of these. I just got these open in advance just to show you how long they've been litigating and how much money and time his previous attorney. Oh, okay. Yes, she is. Yeah, I know she has a really good reputation. I don't know her. I don't even really know Drew, just other than by reputation. So this is the response brief. It's from the judge, but it was written by somebody else. I assume somebody in his office. Look at this. It's George Bellamy, aka Michael Johnson, aka Lamar Ellison. His real name, I believe, his real name is Michael Johnson. So it's one of his AKAs, you see? So it's in there. They know that like, this is one of his names. They just got the wrong um they just got the wrong, AKA. Like you just need to switch these and you're good to go. 16 years after his conviction, he filed a motion for leave to correct indictment misnomer. Bellamy argued that his legitimate name is Michael Johnson and that George Bellamy is a misnomer. Court did not rule on the identical motion. They denied his application for review. prior to filing based on a complete absence of, that's probably justiciable issues of law or fact that cannot be reasonably believed, this court could grant relief against any parties named in said pleadings. So this is an attorney who spent the time writing this. Apparently he's seeking mandamus, which is just ordering the judge to issue an order either for or against, just to take action. Does he have to file under the name he has, or does he file as his DOC name? I honestly don't know the answer to that question, Creed. I actually have been thinking about that exact question recently because I'm representing somebody that has for years got, like, I think I mentioned this recently. He like has to remember the name that was given to him by the Department of Corrections. So anytime, like, he gets in trouble or has to appear in court, which isn't frequently, to be fair, he has to remember like his whole fake identity. And I want to file something with his real name, but I'm like, is this just going to be like creating too much confusion? And should I just continue with the fake name, or will I become complicit in the stupidity? And I'm okay with being complicit in stupidity as long as I'm not the stupid one. But it's getting kind of close to the line. You know what I mean? Oh my goodness. Hey everybody, Karen, now we're just going to take a quick look at this. Give it a few minutes. Can you invent a hyphenated name? I'm not going to inventing a third name. We're not going to any further down that path. Certainly not as bad as, what was the one we looked at last week? The one in the Stop Cop City? It was, what was her name? It was so stupid. Let me pull it up. If I don't look it up now, I'm just going to go insane. Right, Brooklyn Court Munch, aka Brooklyn Court Munch. It's not one of these situations. It's just a completely incorrect name. I still want an answer on how this happened. Count the misspellings of defendants. Don't even, you know what? It's too late. I'm already started. Actually, I might not be able to do this anymore because Fulton County, some of their websites are down. I bet this is going to work. I've already ranted about this like a number of times. Nope, it worked. Here we go. Switch this up. No, not you. There we go. This one right here with the Napoleon Matthews. But if you go back, it says Antonio Sledge. But if you click on Antonio Sledge, it gives you Napoleon Matthews. And I searched for Antonio Sledge. This one might be my favorite, though. And I've shown this before. This one. The nicknames for Antonio Sledge include a bunch of nicknames. These are just people that they've confused him with. Like Kenny Shepard and Anthony Sledge. Anthony Bernard Sledge is actually a real person. It's just somebody else. AKA Antonio Sledge. Just his actual name. Antonio Bernard Sledge, that's a hybrid of Anthony and Antonio. His middle name isn't Bernard. That's just a hybrid of two people. And then Antonio Smith. But if you notice, none of his nicknames are actually Tounk spelled the way it's spelled in court filings. So his actual nickname isn't even one of the AKAs, which I found just delightful. Anyway, so back to the case we were looking at. This is the next filing. This is from the Attorney General's office in that state, or county, rather. Another whole brief. Trial court's denial of the mandamus filing was all they had to do is just call him by his real name. They didn't have to spend any money doing this stuff. Judge Rumor ruled, making it duplicative and moot. Now we have a Georgia Supreme Court opinion. They reversed the judge. The inmate won at the Supreme Court level, representing himself. The Supreme Court smacked that shit down and said, no, you're all idiots. George Bellamy, aka Michael Johnson, is correct. That's embarrassing, but also funny. We granted George Bellamy's pro se application for discretionary appeal, so he doesn't even have a right to appeal. They chose to let him appeal. The Supreme Court did. Whether the Superior Court of Muskegon County erred in entering an order denying the filing of Bellamy's petition for mandamus, for the reasons set forth below, we reverse. So they lost to a pro se litigant, a judge, and the DA because they didn't want to call him by the name and the judge didn't want to rule on it. We have another round of briefing in 2019. I think this was handwritten, so some of the stuff isn't transcribed correctly, the way Westlaw scans the briefs. But he writes this whole long brief. I read it previously. It's pretty good. I would argue that's better than what the DA wrote. It's this whole lengthy brief explaining why he wants to go by his name. I keep clicking that. And appellant was originally arrested in this case on arrest warrant under his legal name of Michael Johnson. So he was originally arrested as Michael Johnson. So that was his first name and his real name. Upon being placed in custody, he was incarcerated under the name of George Bellamy. Appellant was presented at a first appearance hearing as George Bellamy. Upon being indicted, the indictment named him as George Bellamy and set forth his legal name of Michael Johnson as an AKA. As a result, appellant was forced to stand trial as George Bellamy, found guilty of malice murder, and was sentenced to a life without parole. I'm sorry. And this is actually a really good brief, but you'll see here that he just wanted to go by his name. Now we have another appellate brief. And think about how much money the state has spent at this point, not trying to not call him by Michael Johnson, and instead calling him George Bellamy. We have a reply brief by the appellant. And that was the end of it, because I assume it was settled at this point. They probably agreed to call him by his name. But this was multiple years worth of litigation and briefing, multiple briefs written by the state, including by the judge's office and by the district attorney's office, all because they didn't want to call him by the name of Michael Johnson. Okay, I don't know if you guys are as amused by that as I am. Man, my chat isn't updating, so I thought nobody was like commenting on me talking. I thought I was just talking into a void, and you guys have been like chatting this whole time. I have the wrong thing. That was like a downer, man. I was like, man, nobody thinks this is interesting at all. Oh, let me switch it. There we go. That's better. Okay. There we go. Okay. All right. I'm happy now. I was like, damn, I'm striking out. I felt like I was a comedian just like bombing completely. Take care now. Kells creates fun how an inmate and a DOC lawyer can cause the panel of the highest judges over millions of people to have to waste time. I know. And it's like the inmate wasn't even like, I didn't read it, but he explicitly says at one point, hey, like, I'm not trying to appeal the murder case. Like it is what it is. I just want to be called by my name for the rest of my life. Oh, thanks, James and Aaron. Well, yeah, I've been kind of following the Fitzsimmons case. I don't want to like get back into it because I don't want to get yelled at again by crazy people like Julie Carpenter. It's her fault I even followed the case the way I did because she yelled at me when I was having a conversation with GSU Grinding. I had no idea who this person was, and I was just talking with GSU about how Law Daddy, what's his name, the hot one, the 60-year-old one, what's his face, you know who I'm talking about. And Julie Carpenter started yelling at me. Oh God, I can't deal with that again. Is it really that big of an ask to get someone's name right, Joe? It really is. Oh, actually, that reminds me. So at the end, I think we're gonna look at the more recent case first, then we'll look at the California case. No, Alessi, Bob Alessi. GSU and I were talking about how Bob Alessi was doing a good job in oral argument. Then Julie Carpenter was like, "Yeah, that's because he's a dirty liar, and you're a dirty liar too if you think he's any good at the law, and you don't know anything about the law, do you?" And then she probably blocked me, so I couldn't reply. Oh my goodness. I got into the case just to be petty about that. It's kind of a free fire zone. Right. Okay. So the case we're going to look at the end was it's the case with John Lewin, who is the prosecutor of ASAP Rocky. Speaking of unhinged people, and what was I going to say? So Al Yockelson was the appellate attorney representing the guy in the case we're going to look at. This is the case where John Lewin covered up evidence. Arguably covered it up. He's basically like slimy about some evidence. It was a cold case, and there was old evidence that was exculpatory, and he fought not to get it in. But Al Yockelson, the appellate attorney, during the ASAP Rocky case, was in like the Twitter comments, and I think he was watching some of the live streams, and people were being like, "Man, John Lewin's terrible," and he'd chime in like, "Yeah, and don't forget about the time he did this." And he like that he genuinely hates. I shouldn't speak for him. He genuinely dislikes John Lewin to the extent that he was like following his career and making sure that he was available to chime in on all the ways in which John Lewin sucks. And I just really respected that. I was trying to get more people to pay attention to him because of how glorious this moment was. But he has like 30 followers on Twitter. But he is the one who beat what's his face? Who beat John Lewin before the Ninth Circuit. Ooh, I shouldn't have closed that. Yeah, no, I'm sad I missed it too. I should have just gone. It's like down the street. Oh wait, no, I had a job then, didn't I? That was lame. Having a job, I don't like that. Okay, so this is the recent case. Pettiness and spite are pretty much all that's getting me through. Oh man, I didn't miss that. I just read the pettiness and spite part, and I was like, yes, I thought I was happy. No, I'm sorry, James. I think you mentioned that the pug wasn't doing well last time I streamed or the time before that. Sorry to hear that. That really sucks. Yeah, that's good. I have a my ex's dog. We're so friendly, but we were together for a long time, and she. I mean, it used to be our dog, but we still keep in touch, and I see the dog from time to time. But she's like 17 or something like that now. She's getting really up there. Yeah, I'm sure it takes a lot of time to get used to that. So I'm sorry, I'm gonna have to awkwardly segue. I feel like we should spend more time talking about the pug. But no, I'm really sorry about that. So I was sorry to hear that. That's really are cute. French bulldogs are like I don't. They're so expensive. Okay. Let's move on. James said so. So this is Jenkins versus the state. I read some of the briefs. I kind of skimmed through the briefs last time I streamed. I think it was last week. The cat broke the cat's gonna cat, right? Where is Cat, by the way? Speaking of cats. Anyway, this is Jenkins versus State. We looked at this last week very briefly. This was the case where the guy has been tried 3 times so far. Or he's about to be tried for the 3rd time. I can't remember which it is. But he had a speedy trial demand. And his lawyer took a 1-week leave of absence. And the question is whether the lawyer's leave of absence constituted a waiver of the speedy trial demand. So that is, let me make sure title's on, sound. And I'm sure the lawyers will explain it. I watched the first few minutes of this last night, and the defendant's lawyer, the appellant's lawyer, was really good. Ooh, nice. I just got this email I'm really excited about. Oh man, I'm so excited about this. This is a case-related thing. I've been trying to find a local counsel in Georgia for this one case. I have like a complete brief. The defendant's family, he's incarcerated right now. The defendant's family had local counsel lined up. And so I wrote an entire appellate brief, or not an appellate brief, it'd be in the trial court level, but basically an appellate brief. And it's like 30-something pages long. And then local counsel dropped out. And so I've been looking for somebody to join me. So like just to work on it and file for me. I was thinking about getting just like the cheapest lawyer I could find, like somebody on a billboard or something. But yeah, I just got a response from somebody who many of you will know. If I don't want to name the names in case it falls through, but they are an extremely good appellate attorney, and they just responded. I'm super excited. I've put so much time into this. I started to think it wouldn't happen, even though it's literally a completed motion. James says, "Oh, thanks, Factual Lie. This is a pretty nice state Supreme Court. Yeah, this was just built pretty recently, actually. This is I think it's the James Deal Legal Center, something like that. Not California. James Deal? I don't know why I did that. Am I making this up? Nathan Deal. Is it Nathan Deal? I don't know. It's from a couple years ago. It's a new building. It's really Nathan Deal. That's right. Look at the lame. Yeah, it's a new building. It's really nice. Hey, Corky. But yeah, it's a really nice building. It's Pinson, who I really like. Okay, let's go back to where we were. Nathan, it literally said on the screen the name. I just didn't see that because I'm smart. Okay, so let's watch this. It's about 30 minutes long. House of Loss. It's called House of Pain. Okay, so let's watch this one. Where's FFS? Have I seen him in here? I don't know. I can't find any of New Jersey's courts online. Really? $4 a minute? Jeez. There's one case I'm working on. Like a lot of the cases I work on are just kind of preliminary. I haven't decided whether to like take them or not. This one's like getting to the point where I'm going to take it. But he has trial transcripts, a habeas transcript, the Supreme Court transcript, and it's like 50 cents a page. I think one of the places is $1 a page. And it'll be like many thousands of dollars just to be able to find out whether his case is like I don't say worth taking, but like there's a real chance of you know, getting some kind of relief. And so instead of me just buying the transcripts for a reasonable price, this guy who's in prison has been taking pictures of every single page of his transcripts and sending them to me one at a time. He he sent me like, and he has to email them to me. He emails every single picture to me, but in Gmail you can only send, I think you can only send five attachments per email, or the image, the file size is such that he can only send 5 per email. So he has to send them to me 5 at a time. I think he sent me like 600 pages so far. So he sent me like 120 emails. He's taken 600 pictures, attached them all to an email, and sent them to me. And he had to reorganize them because the guards keep coming in and like fucking up his like legal papers. So he has to like reorganize like thousands of pages on a semi-regular basis. Yeah, somebody else confessed to the crime that he's in prison for. He's really funny too. He's really smart. He wants to like help people in his situation when he gets out. He could be a lawyer. He's smarter than most lawyers I know. He's better at the law than most lawyers I know. I really like him. We get along really well. We were talking the other day about like different kinds of post-conviction relief, and he brought up a really interesting point. Actually, he said that you only get like one shot at your appeal in general. He says like when people get into prison, they just want to appeal as soon as possible, and he did the same thing, and because of that, like he wasn't really ready for the appeals process. It hadn't like sunk in, and he hadn't like gotten organized and all that stuff. And so he just got like the first, appellate lawyer that he could, and just did everything as fast as possible. Then he lost. And we were kind of talking about how the system's set up to get people to like not have a great appeal. That's not like the intention probably, but that's just kind of how it works. Because you get one bite at the apple and you try to bite it really fast. And you miss the apple. But yeah, he's really smart. I really like him. I think whatever happens, we'll continue talking. We're pretty friendly at this point. Don Adelson wants a new trial. I can't even deal with that one. I just know that one's a headache. I think it depends on the appeal. Like I think for a new trial motion, you have a shorter period of time. Then you have like 4 years for certain appeals. Yeah. I agree, James. Okay, I'm gonna stop talking for a little bit. We're gonna watch this is Niels, I think. Or is this Niels? That's Andrew. Let me see. Sean is this one. That's Sean LaGrua. Those are the only ones I know.
5A1050, Roshan.
Man, I'm in a good mood. I haven't streamed for a few days. I was kind of down last time. New trial is 30 days. Yeah, that's right. And I know probation revocation, because I'm a parody of myself and I only ever talk about probation. Appeals of probation revocations are 30 days too.
Jakari Jenkins versus the state. Ian Busey for appellant.
Aaron knows more of this stuff than I do. Ooh, I like this jacket.
Mr. Busey, you may proceed.
I was really impressed with this guy too. I watched the first few minutes, like I said. Someone else successfully got her murder conviction, sentence lessened, but it took years and a whole lot of money. Yeah. Okay, last story, and then I'm gonna hit play. I was contacted recently. Okay, so apparently it's really easy to have a cell phone in Georgia because people who are inmates in prison keep sliding into my DMs asking for like help with their cases. I've had an easier time getting in touch with people who are in prison and not supposed to have cell phones than like their lawyers who are out of prison. Like, it's remarkable. There is one guy I'd never spoken to him, and I did a video about him, and he like DM'd me and he's like, "Hey, thanks for the like." I'm like, "Are you watching my streams? How do you even? We've never spoken before." Oh man, that was funny. But anyway, I should even continue telling the story. But yeah, he in his case, he started trying to represent himself, and then he realized that he was in over his head, and he asked for a lawyer, and the judge said no because it was she thought it was gamesmanship. So he wasn't allowed to have a murder in a case where he ended up getting sentenced to 30 years. And he didn't even hurt anybody. It was a non-violent crime, and he got 30 years. You're eligible for parole after 30 years if you get a life sentence. But yeah, he got 30 years for a non-violent crime. Um, which I didn't even. He got 2 consecutive 15-year sentences. Um, it was um, like a drug distribution thing, but he wasn't found with any drugs, and it was based on conspiracy. So he'd been at somebody's house where apparently there were drugs, and then he got arrested as he was leaving the house with no drugs. And they're like, "You were conspiring to deal drugs," even though he had just left the place where there were drugs and had no drugs, and has never been convicted on drug stuff before, and has no history of drug use or drug selling. No, no guns involved. There were no weapons whatsoever. It was Wilcox County. Yeah, 30 years, consecutive 15-year sentences for a drug charge is wild. Um, yeah, this one's definitely an outlier. I think judges are pretty like to get consecutive sentences. You really have to piss somebody off, unless it's like a mandatory consecutive. Erin probably knows more about that one than I do. She can probably give you examples. But if you're, I mean, no, I'm not going to make that joke. But yeah, it's pretty rare to get mandatory consecutive. Were the other people arrested too? Yeah, it was like there was like the house, and there was a married couple that lived there, and they were arrested. They confessed. The wife confessed to a crime, so it's not like there was no crime. But yeah, there was. I mean, he'd just been at the house. And I mean, guilt by association, I guess. That's basically what their whole case was. Just like, oh, he was there, therefore it's conspiracy. And I haven't looked through all the transcripts yet, so I could be wrong. But that's basically what it looks like so far. Um, he was in the car, and apparently there were like things that kind of looked like drugs but weren't drugs in the end. They're like they're packaged like drugs, but they weren't drugs. It was just like innocent stuff. So he got a I think it was conspiracy to. It wasn't conspiracy, but it was like drug distribution, even though he didn't have drugs, because they thought that he had packaging that looked like drugs. I guess it's probably like having something in a baggie. I guess I don't know. Compiling dirt on Georgia departments. Yeah, I think I've used that before. I shouldn't say that out loud on camera, but I think I've looked at Shields of Shame because I was trying to just find out who an officer was, and they had some information on him. Maybe they lie on him and said some of it was his. Yeah, it could be. It definitely could be. Outside of firearms, the only mandatory consecutives, recidivist. Yeah. Oh, hey, cat. I was just wondering where you were. You were talking about cats, and then that reminded me. Nice. I just did. Were you here when I told you guys about how I did a public records request for the dog's training records? I did a FOIA request for what are their names? Jumbo and Banshee. Jumbo and Banshee. I know all about their records. I know all the dirt on those dogs. They're good boys. It'd be funny if I did a FOIA request for a dog and it was like Banshee, he was disciplined. He has a disciplinary record because he peed on, Officer Gray's shoes, and he ate Viverito's lunch. He was suspended without pay for 2 weeks. Oh man. Jumbo. I can't remember which one was Jumbo and which one was Banshee. I think I'm not going to say these. I'm just going to say something I shouldn't. They're good boys. Okay.
Proceed when ready.
Kat, this is the case I read about last week. The one with the Caligula suspended without treats. Yeah. This is the one with the speedy trial demand. I think you were here for that.
Morning, Mr. Chief Justice, and may it please the court. My name is Ian Busey, and together with my co-counsel Courtney Morgan, I have the privilege of representing.
He just looks like a Southern gentleman. He just has that look.
Mr. Rashad Jenkins.
Caligula is a wild name for a dog. I'm sorry.
We're here today because the trial court erred when it improperly dismissed Mr. Jenkins' speedy trial demand under OCGA 17-7-171. The court made two key errors when it did so. First, it improperly equated Mr. Jenkins' trial attorney's leave of absence with a motion for continuance. And second, it improperly scheduled Mr. Jenkins' trial during that leave of absence. Now, I do appreciate that the court has done the 2 minutes of uninterrupted time. However, I appreciate your feedback much more than my guessing what feedback you want. So I do happily take questions at any time.
Wait, do they get 2 minutes of uninterrupted time to speak and then they can be questioned? I didn't know there was a 2-minute grace period. How am I? Oh, other James, my bad.
In light of that, let me ask a question. You agreed that on November 22nd and the 25th, there was no transcript for either of those occasions, correct?
Yes, Your Honor.
So tell me, as it relates to both of those
What's her name? Colvin. Okay.
dates, what happened? Particularly, what did trial counsel do during that time when all of this discussion was being had?
So trial counsel had filed her leave of absence back in October before the second trial even took place. And at that,
And again, the trial in question is going to be the third trial. The first trial was a straight hung jury across the board. The second trial was an acquittal on 5 of the 8 counts. And the third trial, I shouldn't say last, would be on the remaining 3 counts. So this will be the third trial. So it's not like a speedy trial demand, and it's the first one. He's really trying to get through this, and it will be his third trial.
November 22nd calendar call, she reminded the court that we have scheduled this trial for December 16th. I have a leave of absence on December 18th. The key factor there is at that same calendar call, the court scheduled every other case for trial on December 2nd.
True, Aaron.
When there was no leave of absence, when trial counsel was available to go. I do have that.
Sorry, just so you guys probably followed that, but there were 2 weeks remaining in the term of court, and one of the 2 was basically when the defense lawyer had the leave of absence. And the first one, there was no leave of absence, but there were trials held that week. So he's saying there was a specific week where the jurors impaneled where they could have had the trial.
With me, the court would like to see that. And this is, of course, in the record, page 403. And it's Judge Green again, Your Honor, at the November 22nd calendar call, trials for December 2nd, other cases at that same calendar call were called for December 2nd.
And there were no other speedy trial demands?
Not to my knowledge, Your Honor.
Did the court acknowledge that counsel had a speedy trial demand in place?
Yes, Your Honor.
How does the potential availability of a different trial date that the trial court didn't choose factor into the analysis that we're supposed to do with respect to whether there's waiver?
Certainly, Your Honor. So when we look at leave of absences versus availability, a big factor is this leave of absence so long, so we might even call egregious, that it berefts the trial court of the ability to even have the speedy trial?
I don't even know that word.
Here, where we have a whole nother trial week, where they could have gone forward, where they had jurors impaneled, and they still chose not to schedule during that week despite the speedy trial demand, that shows clear error.
Does it matter?
I just discovered I have a note. It says fully subjective, and then there's a case citation. I have no idea what case this is for, like what it means. I bet I had a great idea like a week ago.
That
About a week ago.
speedy trial demand was filed after counsel had already assumed the role as counsel on the case. So when she first got in, she didn't file the speedy trial demand. It was sometime after.
Yeah, I did that, Kat. I asked for a vacation of 1 week, and that was an egregious request, and I was told to never do it again.
Does that affect the court's requirement to honor that speedy trial demand?
No, Your Honor, and in fact, I don't think it's super relevant, but because it does matter a little bit, there were 2 speedy trial demands filed in this case. He was indicted in November of 2023. That first speedy trial demand was in January of 2024, so very soon thereafter. The trial court, without a hearing, dismissed it because the trial court was not listed on the certificate of service for that speedy trial demand. I know service is required, but being listed on the certificate of service I don't think is grounds for explicit dismissal of that.
Can you articulate what you think the rule is? And what I mean by that is, if all of the other cases scheduled for December 2nd had statutory speedies filed in them, like who would get priority under your construction? Like what rule could a trial court in the future apply and know that they were getting this right?
So I think one of the best cases on this is Burks v. State, and it is a Georgia Court of Appeals case. But Burks v. State says we look at all the availability, how much time did they have during that term of court? Here, the terms of court are 3 months each, so they're pretty lengthy terms of court. We have other terms of court that are 2 months. We have others that are weeks back to back. So here, where the trial court has an available week with jurors impaneled, I think it's pretty clear cut.
That's crazy that there's a county with a 1 week term. There are some things you have to do within the same term of court. A motion for, what's the word? Motion to change your sentence. Motion to correct sentence. Motion to modify. Motion to modify. I think it's different now, but for a while it's the same term of, you have to file it in the same term of court as the sentence being imposed. So if it were like 1 week, you would have 1 week to notice the error in the sentence.
Because there was...
What if there was a statutory speedy in each of those as well?
Well, then I think as Burke states, 17-7-171 doesn't say if jurors happen to be impaneled, then speedy trial is effective. The county and the court may be required to bring in jurors in other weeks that they didn't plan on.
And so how would you know is what I'm asking. So let's imagine that the November 22nd was in fact December 3rd. And so the week of the 2nd wasn't available. Like what I'm trying to get at is, what is the rule that governs the trial court? When there is a leave of absence that is approved, how can they know that they have satisfied their obligation under a statutory speedy, or are they ever allowed to consider the leave of absence as functionally a motion for continuance?
Yes, Your Honor. So this court does have case law where, for example, a counsel took 30 days of leave of absence during a term of court. Here we have to look at...
I wish you just said, that's not my problem. That's if the court grants the speedy trial demands and it grants the leave of absence, exactly, Weppy. I mean, you have to have 2 things granted for this to even be a problem.
At how much notice did the trial court have? And here in the county where it's 3 months terms of court, so effectively they have 9 months to try this case. The leave of absence was...
Yeah, it's the statutory demand. It is, it's the current term of court plus 2 terms after that. So in Fulton County, that's 3 months. Shout out Jeffrey Williams.
December 18th through January 6th. Every parent here knows that's when kids are out of school. The court is in session 6 days during that time. So when you compare that with the 9 months they had to try the case, I think it's very clear that there was that opportunity.
So when we're looking for what the rule is, Our case law is very clear that if you seek a continuance, you're waiving speedy trial. And so the question is, when does a leave of absence amount to a request for a continuance? It seems to me that this may be an area where a bright line rule isn't really that useful or applicable. Like on the one end of the spectrum, if you've got a specially set trial for this day, and you've got a speedy trial motion that led to the specially set trial, and then you file your notice of leave of absence, that you would agree that is the functional equivalent of a request for a continuance, right?
Yes, Your Honor.
See, I feel like the judge should just deny the request at that point. Yeah, exactly, Aaron. Like, if you got to keep those things in mind if you're a judge. The judge is tasked with managing his calendar, managing his docket. Deny one or the other.
On the other hand, let's say you had
I'm sorry,
a request that you'd filed 6 months earlier for, I'm going to be out 1 week. That's probably not a request for a continuance. This case seems to me to be somewhere in between those. A request for 1 week, if that's functionally a request for a continuance, even though it happened 6 months before the trial got set, that's essentially saying that criminal defense lawyers can't ever take vacation.
Hey, next time Tiffany streams, I need all of you to go to her channel. Tell her to take some time off.
Exactly.
And that can't be the rule. So it seems to me that the rule is somewhere in the middle, which is fuzzy, and I don't like fuzzy rules. So help bring some clarity to what seems fuzzy.
The judge needs to manage that. Matthew, do they need permission? I think this might be a Georgia thing, but yeah, basically, if you have like a case that's pending, you file a leave of absence. Isn't she in Europe? She'll leave. Okay, yeah. Let me finish Matthew's things first. You need to file a leave so the court doesn't like calendar anything during that time. This actually came up in YSL when Ashley Merchant, she filed a leave of absence like months in advance for like a week and a half, 2 weeks. And I think it was like September maybe or October. And she said, if you want to call my client as a witness, you need to do it before that. And once those 2 weeks came, they tried to call her client, even though she had a well-established leave at that point. And Judge Whitaker said, no. First of all, how dare you? So yeah, you do need to file it, but usually it's not a big deal. I mean, it's just to give a heads up. Just so they don't calendar anything in a bad time for you. It's just logistically, it's not a huge deal. It's very rarely denied. If you're like stupid with it, they'll deny it. Next question was, isn't she in Europe? Yeah, I think she's on vacation, but like, there's a difference between leaving Georgia and stopping working in Georgia. His attorney from Houston is the after ex parte party. Yeah. Ashley is boss. Yeah, Ashley sent several letters. They were fantastic.
So Burks v. State, again, a Court of Appeals case, I know. It's very similar to this one. 2.5 months to try the case. Trial counsel took 7 days leave of absence. Here, I think, and again, I realize it probably is totality of the circumstances land because it is difficult to do a bright line rule. But in this case, where you literally have an entire trial calendar week set without all speedy trial cases, and the judge chooses to ignore that week, even though it was no.
He just said he wasn't sure if there were no speedy trials like a minute ago.
Just months in advance. I think there is a possibility for a bright line rule in that circumstance.
Did the judge give a reason for ignoring that week? You say he ignored it, but.
No, Your Honor.
I don't think I've ever seen this guy speak before. I don't know who this guy is. Who is this?
Calendar call, instead of saying maybe we should bump this up to December 2nd, they just set it for a show cause hearing.
And did trial counsel say, I'm sorry, I've got to leave, I cannot be there December 16th? Is that the response?
December 18th, yes, Your
Or
Honor.
December 18th?
Yes, Your Honor.
And the court didn't say anything in response to that?
On rebuttal, fortunately, trial counsel is my co-counsel. I'm happy to get clarity there, and I'm happy to bring that back.
Well, is there anything in the record on that, though?
There's nothing in the record on
So, I
that,
mean,
no.
But
all of this is,
that's because it wasn't transcribed.
Correct, Your Honor.
Do you,
And to make clear, it's not that it wasn't transmitted to us, it's that it wasn't transcribed in the first instance.
That is my understanding, Your Honor.
do you know whether trial counsel said, I'll take December 2nd?
She would have loved to take December
Do you
2nd.
know whether that was said? We have no way of knowing, I guess, because there's no transcript.
It's not in the record, but she had already been successful in 2 trials previously. She was very eager to have a 3rd trial and get this.
Is that common not to transcribe at the calendar call hearings?
She is really unhappy with the fact that this wasn't transcribed. And she has a reason to be.
I can't speak for that county, Your Honor, but I really wish it had been.
does the lack of the transcript, I mean, that runs against you, right, as the appellant?
It could, but in this case, where we have a clear record that there was another available trial week, and that's just a trial week where there was jurors impaneled.
Does the state agree with you on the facts that you've told us about what happened at the hearing?
I can't speak for them, but I do believe it's not undisputed.
Okay.
You just hit a double negative there. I know he didn't mean to, but that was, if he had, that would have been wonderful.
Does the state agree with you on the facts that you've told us about what happened at the hearing?
I can't speak for them, but I do believe it's not undisputed.
Okay.
So your position, I think this was Justice Bethel who was asking earlier, if a trial judge has so many speedies within one term of court and only a certain week where jurors are going to be impaneled and trials are going to be held, your position is if there are too many speedies to be accounted for during that time, that the judge then has to impanel new jurors and create new trial dates?
Say yes. Say yes. One word answer. Just say yes.
Well, that's what the Court of Appeals said in Burt's, and I'll quote, the dismissal language in 17-7-171 does not condition itself on there being enough juries impaneled and qualified, or how many jurors there were, or whether there were
It's a demand for a right to speedy trial. It's not a request. Like it's not the defendant's job to get themselves a trial scheduled.
enough criminal trial weeks scheduled in 2 terms. If we analyzed every case on such a basis, the statute would be gutted and the rights provided by it would become empty, depending only upon the states and the court's convenience and ingenuity.
But you don't need that rule.
No, I don't.
Because because the December 2nd calendar is not full of cases that were on.
Yeah, in my ideal world, which I know doesn't matter,
Yeah.
if there's another juror trial week established and the court chooses not to use it, that would be a violation. If that doesn't exist, then I think we go into totality of the circumstances, which says, is there the opportunity to impanel another set of jurors?
So going back to my earlier question, I heard what sounded like maybe a rule there.
Yeah,
right?
that last part was good.
Would you suggest that as a preliminary matter, not with respect to what else may be out there, if there is a pending statutory speedy and there is a continuance of reasonable length, again, reasonable, it gets scary because it gets fuzzy and the chief doesn't like my fuzzy, but of reasonable length, then if there's an available
The
week
chief doesn't like my fuzzy.
it is not otherwise occupied by people with statutory, in that case, it's an abuse of discretion or whatever the standard, right, to not set it then? Is that fair?
I would say yes, but I would say it's not a continuance, it's a leave of absence.
And it has to be asked
To
before the
interpret it as
speedy,
a
right?
continuance.
Correct.
The before and after makes a difference.
Yes, I agree, Your
So you
Honor.
can't file your speedy and then ask for leave or continuance,
Yes. Well, you can file the speedy and then request a leave of absence.
but not a continuance.
Yes, Your Honor.
And
I
so
agree.
if your leave of absence somehow is deemed a continuance, then you're in trouble.
Yeah, in Knight v. State, and this is another Georgia.
There's a way to do this for the judges to manage this. Is if you get a request for a leave, just explicitly ask them on the record. Is this if you stipulate to a continuance, then you can have your leave, and if you don't, you can't. Like again, this can be managed.
Court of Appeals case. There's language that says appellants do not contest that the timing of their counsel leaves of absence was such as to prevent their trial from otherwise having been conducted during the remainder of the term.
Counsel, the case that you cited, was it a different statute that the court was looking at? 177170 and not 177171, and does that make a difference?
I don't believe it makes a difference. It's whether it's a capital case or not. So I think the same rules should apply to both.
Okay.
Counsel, let me ask you this. The trial court in 3 separate orders said that the defendant asked, at the request of the defendant, a continuance was granted. I mean, that is a factual finding by the trial court. Is there anything in the record that undermines
Wait, I missed
that?
that.
I mean, other than you're saying granted. At the request of the orders said that the defendant asked, at the request of the defendant, a continuance was granted. I mean, that is a factual finding by the trial court. Is there anything in the record that undermines that? I mean, other than you're saying that there was a leave of absence and the trial court construed it, but I mean, in the absence of a transcript, don't we have to presume that that's true, that defendant asked for a continuance?
No, in the order we're here on today, the court explains that they're equating that leave of absence with a continuance.
No, there are 2 other orders, though. There are 2 other orders in the case. There are 3 orders total that say defendant asked for a continuance.
I think you can get around that because they did explicitly once explain. So that same explanation should hold true for the other 2.
And there's nothing in the record that would indicate that is apart from the leave of absence. There was no request from a continuance from my client.
But we don't have the transcript from the November hearing where that continuance could have been requested orally.
Was the leave of absence transcribed? Was that a piece of paper?
I believe that is in the
And
record.
was it labeled leave of absence?
Yes, Your Honor.
So if the trial court decided that that was a continuance, not a leave of absence, is that a factual finding or is that a legal conclusion or some kind of mixed question?
That would be a legal conclusion because, as I stated in my first enumeration of error, they improperly state a leave of absence as a request for continuance, and that is seen throughout the orders, as Justice
Does it
Memon
matter whether it's a continuance or not? I thought the statute said you've got to be ready in court announcing ready for trial.
It does
It doesn't
matter.
speak about continuance. A continuance is one way to affect a waiver, but if you're not present in court when the trial judge sets a case down for trial, that's a waiver, isn't it?
It is, and that is not what occurred here. In fact, the leave of absence began December 18th.
Well, Mr. Bucci, the original Rue Nisi was issued on October 30th, correct? And there was no announcement for a December 16th trial. She made no contact with the court between October 30th and November 22nd, did she, objecting to that calendar that was published?
No, but again, there is a period of time between when that order comes out and when it's received.
All right. Thank you, counsel.
Good morning. Good morning, Chief Justice Peterson, Your Honors. Kelly Weathers on behalf of the state of Georgia, the Dublin Judicial Circuit District Attorney's Office. And I too welcome interruption and question at any time.
I want to go the other way if I'm ever before them. May it please the court, don't you dare interrupt me. Terry versus Ohio. I'm sure it will.
I am somewhat handicapped about November 22nd because I commenced my service with the Dublin Judicial Circuit with the newly elected district attorney on January
don't bring this
1st,
up.
so I inherited this.
Don't do this.
So you can attest to what appellant said regarding the facts, namely that it was, what happened on the 22nd, what he said happened. Can you attest to that?
I was working for Bobby Christine in Columbia County on.
I mean, it wouldn't matter, right? If it's not in the record, it's not in
And
the record.
there's no record of it that I was
agree.
able
The
to find.
cases say if you all agreed as to what occurred, then that would make a difference. But you saying you can't agree.
That's correct, Judge.
Okay.
And for me, this case goes back to the distinction that Justice Land pointed out, the language in 177171 present in court announcing ready for trial. The trial court in its order dismissing the statutory speedy demand anchors on this court's rights decision, which indicates that we strictly construe that statute.
Does that mean that a criminal defense lawyer can never take a vacation?
I do not.
Yes.
I do not believe that that's what it means,
It is
but
what it
it
means.
doesn't go on
Well, then
to.
how do you take a vacation?
Looking at well, you don't like the totality of the circumstances.
Well, no,
Liam, but
I mean,
it's-
totality of circumstances
yes.
may be the answer, but the argument I understand you to be making is you're either available at
Yeah.
all times.
Because if the court schedules the trial during your vacation, you can't go, and you have no control over when it's scheduled. That's exactly what it means.
During the relevant terms of court, or you've waived.
Well, I think this comes down to the tension of the agency of the trial court to govern its own docket, knowing what other obligations it has. Perhaps
which is what they need to
if
do.
all cases had a stat speedy, then how does the trial court govern that? At the time that the trial court specially set this case for trial, Ms. Morgan's leave was on the record. She filed that October the 6th. October the 30th is when he specially set it, so we can assume that the trial court knew she had that. And I found...
so what you're saying is the court fucked up. That's what I'm hearing. That's what I'm hearing you say.
Again, this is Court of Appeals authority, but I was surprised to see there was a case, Summage versus the state, and I believe the trial counsel there had filed a leave of absence that conflicted with the court's ability after a stat speedy was asserted, and his leave of absence conflicted with the court's ability to get the case tried. So he actually revoked his own leave of absence.
Doesn't that seem materially distinguishable? I mean,
Yes.
if somebody files a leave of
Yes.
absence or a continuance, whatever you want to call it, and it somehow occupies the field such that there's just no
I don't believe they have to do them in January, but they do have to be approved.
possible functional way you can hold a trial, that's one thing. And I don't hear you saying that that's what has happened here. Certainly the other side would not characterize it that way.
Well, in this case, we had 2 mistrials that occupied 10 days.
I don't think that matters to the question of when this trial could be set, given the available days in the term, and the fact that other trials were set for other days where juries were going to be impaneled.
Well, one note.
Yeah, this is an interesting case because it seems like the facts here militate in favor of granting or dismissing the case because there was that specific week. And there are like facts in this case that suggests like there should be a dismissal here because the speedy wasn't honored, as opposed to like Supreme Courts generally establish like general rules, and so it seems like they're trying to balance managing this specific case versus like the general rule.
We had Hurricane Helene, which shut us down for
Other trials were being held.
And the
she's quickly becoming my favorite.
December 2nd calendar, I pulled from the clerk's site. I don't know if that made it into the record. I think it was a late request. This case was not actually on that particular trial calendar, although they shared the same calendar call day. This case
Isn't that the problem? That it wasn't on that calendar?
I think it goes back to the trial court's agency to govern it.
But yeah, and they need to exercise that agency correctly. Exactly.
Counsel, when we actually look at the order that is being appealed here.
I really like this court. I like pretty much everybody. Like sometimes they annoy me, like individual, justices, I disagree with them, but they all seem like, eminently qualified and genuinely interested in the law.
The order notes that there was no objection to the leave of absence.
Correct.
And that under the Uniform Superior Court rule, because the leave was less than
that's how USPS does it. In December, it goes by seniority. Everyone chooses their vacation for the next year. If you're last in seniority, you don't get days you want. My dad was a mailman, actually, so I'm familiar with the USPS vacation system. We had like the US mail, like they had like the same day off schedule, and every day of the week is like a different color. And so if you're like the blue seniority, you get like different days off, and so I could look at like my dad's calendar and I could see what days he was going to have off because I knew what his color was. My favorites are her and the one justice who said try again. Yeah, I think that was Pinson. The 2 redheads are like the stars of this court.
30 days and there was no objection, it stood granted 10 days after it was filed. So in mid-October, as a matter of law, the leave of absence had been granted by operation of law.
Correct.
So by the time you come to the calendar call, there's not a pending leave of absence. There's a leave of absence that has been granted by operation of law. Does that change the calculus here at all?
Yes.
I think it's important that we can assume the trial court was aware of that leave of absence and said...
Yeah, of course. Sorry, I'm not going to interrupt again.
We can assume because the trial court says...
Thank you. Thank you, Your Honor.
in its order that that had been granted by operation of law 10 days after it was filed.
Yes,
Correct.
and so in looking at the
Yes,
remaining
that's how that
days
works.
available to the trial court, given Hurricane Helene, given the fact that they'd had 2 missed trials, and then working around other leaves of absences, and with the, there was a change of administration that was,
We don't care about the change of administration.
everybody knew it was going to be a substantial change of personnel.
That's not the defendant's problem. Figure it out. It's not their job to accommodate the district attorney's office. That's why they have the statutory steady demand. I was on such a roll there, and then I fucked it up.
I believe that was when the court said in its order that's being appealed, that was the first opportunity for that case to be tried. I believe we should be able to rely upon the trial court's decision about his own docket.
But if it's a speedy trial demand, even if it's not on the calendar, if the court is apprised of that, doesn't the court have a responsibility to try to ensure that they try that case when they have jurors ready?
And I think this is where we're handicapped by the absence of that transcript, because I don't.
Stop it. You can check the cases and see whether there are speedies pending in the other cases.
Don't know what was discussed that day. I do know that the orders that were entered on their face appear that this was a request of the defendant over the state's objection to move it from that December trial date to the January. And I think that when you consider why we strictly construe the statute against the defendant, obviously the outcome is draconian. And
Stop. You've already lost 2 trials.
8 days into a new administration,
Stop mentioning it's the new administration. Nobody cares. That's relevant to nothing.
I was ready for trial and would have been ready for trial. If the court decides that this was an erroneously dismissed statutory demand, I think I have maybe a week or two to pull it back together and try this case. And it's a murder case. I don't think that
has no relevance to anything.
Fairly be argued that the state has not been diligent and ready at every turn.
You've been diligent at taking those L's.
There was one continuance the state requested.
Yeah, no, there's no question of state diligence. The problem is the statute isn't just is the state ready? It puts an obligation on the judge and the defense lawyer and everybody else as well. The statute.
Yeah, and draconian means like a harsh punishment. It doesn't mean no punishment. That's the opposite. Like you've already lost twice. Come on.
A bright line statute that does impose a draconian remedy, and it doesn't appear to have been updated in quite a long time.
And I think if the legislature would address in the statute the interplay of leaves of absence in announcing ready for trial.
No.
That would clear this up. But
leaves of absence are principally a creature of the uniform superior court rules rather than statute, right?
Yes, sir. So, when I consider the circumstances, I go back to that present in court announcing ready for trial. And it exists in the capital statute, but not in the non-capital speedy statute. I think that there's some value in that distinction as well, which would indicate.
So is your argument that
It comes back to his first question: how do you take a vacation?
Leave of absence or not? If it's a capital case, you got to go when the trial is called. If it's not a capital case, the rule may be different?
Yes.
Because the statute's different?
I think that would be a fair way to interpret the distinction between the two statutes.
Rice makes that distinction, or at least says we construe this more strictly, and that the other statute and cases governing it maybe don't matter as much in the analysis.
Yes.
What does it mean to construe something strictly rather than reasonably? Does that entail unreasonable construction? Or are we just supposed to construe everything reasonably?
Well, in the context of what the impact of an assertion of a capital stat speedy and then dismissal thereafter, it's a draconian outcome for.
When we're talking about construction, is there a difference between construing text strictly and construing it reasonably?
Yes.
Or are we just to construe everything reasonably?
This is deep into like legal philosophy.
I would, when I read that a statute's to be strictly construed, I anchor my thoughts to the words that the legislature chose.
Isn't that what we should do in every construction opportunity?
I re-anchor every time I think about each issue, though, when I'm dealing with a statute that has been deemed to be strictly construed in some manner.
Well, and just to be clear, I mean, I think I misspoke when I quoted Rice. It requires strict compliance with the statutory requirements to the extent that there's a difference between compliance and construction. I guess my other question is that the decision under review here is a decision that the speedy trial right was waived. What is our standard of review of that decision?
Ooh,
is it abuse of discretion or is it de novo?
De novo. He's going to say abuse.
I believe it's a de novo review.
Because we would be reviewing the trial court's determination that what was requested was in fact a continuance as opposed to a leave of absence. Is that the idea?
I mean, that sounds.
Is Melly trying to get this case dismissed on this argument? I don't think so. I think he did at one point. It's a different statute in Florida too, but I think he did try to get a dismissal on a similar issue.
Or just that waiver itself is as a matter of law. That's a legal decision, so we review it de novo.
I believe because it's a legal decision, it would
question.
be a de novo review.
So part of the question here is what in the order really is a finding of fact versus a conclusion of law. And it seems to me the key line on this point is at the bottom of the first page and the top of the second. Because defense counsel went forward with her leave, the court had to continue the case at the request of the defendant over the state's objection, which seems kind of somewhere in between. Like, clearly it's based on the fact of the leave, and the court is interpreting the leave.
I should say he filed a concurrent. He wrote a concurrence in a recent speedy trial case. It wasn't a statutory speedy trial case. He's really unhappy with the way speedy trials are being administered in Georgia right now. This gentleman.
Leave as a continuance. That is not a factual finding by the trial court that trial counsel made a motion for a continuance or requested a continuance. It is a determination that because you went forward with leave, that was tantamount to a request for a continuance, right?
Yes, sir.
Okay.
I also think that on the in the first paragraph of the court's order, the court identified December 16th as the first time a trial week was available. I recognize there was a trial, there was December 2nd, and I think in briefs they noted that another court had December 9th. But the reason that I point to that sentence is because I do think that speaks to the trial court's agency to know what is upon the trial court in its own scheduling of things. And
yeah, but it can't be letting these things happen.
We don't have any idea from the record why other trials were scheduled or not scheduled. And in fact, this case that was tried the second time, which resulted in 5 verdicts,
5 acquittals,
ended about 3 weeks before the calendar call, correct?
this procedural history required a new
October
packet.
28th to November 22nd?
Yes, that's correct.
So we have no idea what had already been scheduled, what witnesses were available, not available, and we have the trial court order saying that this was the first available week he had for trial.
Yes, yes, ma'am.
Do you have any case law that distinguishes between a mistrial based on verdicts and a mistrial based on just a hung jury? So I haven't been able to find any.
I do not. I profess, when I was writing my brief, I looked at that, but obviously didn't include it because I didn't find anything.
So I looked at that too, and what I found was that what the precedent says pretty clearly, except for one sort of unique factual situation, is that only mistrials that happen through sort of act of God, judge gets sick, jurors get sick, that sort of thing. Any other sort of mistrial doesn't count as a trial for purposes of statutory speedy, with the exception of one decision of ours when the mistrial happens on the last day of the term.
Yes.
Is that an accurate,
That,
to your understanding, that's an accurate
yes,
statement?
sir.
Okay.
Yes, sir. And that's my argument. Any other questions?
All right, thank you very much,
Thank you.
counsel. Mr. Busey, you have 5 minutes remaining.
Thank you, Your Honor. So one
Counsel,
quick.
what do we do since your colleague on the other side can't
She's really interested in this case.
agree to all that you attest to initially?
So one key point, which I just learned from trial counsel / co-counsel, is that she does believe the November 22nd hearing was taken down. It was just never transcribed. So I do think I'd be able to do a motion to perfect the record to get that. And
So what fact is there that is unclear at this point based on what the trial court put in the order at the bottom of page 1 and the top of page 2?
I agree, Your Honor. I truly don't think that this is a question of did she request a continuance or was it a leave of absence. I think the trial court makes clear in that order that it was a leave of absence, and they said, well, we're going to treat this as a continuance.
You concede, however, that she was not present in court announcing ready for trial.
Well, at the calendar call, she was announcing ready for trial, and she asked.
December 16th, when the case was set.
Well,
Or did she tell the judge, I will not be there because of my leave?
she said, Judge, I have a leave on December 18th, which of course is 2 days later, and the judge, instead of proceeding on December 16th, did a show cause hearing for January 8th, saying, why should this not be dismissed? So she asked, and the transcript, when we're able to perfect the record, will show that she asked to go forward on December 2nd. And the judge said, no, I'm scheduling it for December 16th regardless, when your leave of absence will prohibit this trial from going forward.
Do you have any case law to suggest that counsel can say, Judge, I don't want to go forward on the date you've given me, but here's another date that works for me, and that we get to hold trial judges to that?
So there's no case that specifically says, Your Honor, that's not great for me, let's do this instead. But there is at least Court of Appeals case law that says if there's other dates available and we have a very limited leave of absence, the trial court needs to use those other dates.
But the trial judge's order says that the 16th is the first available date.
And we have records.
Do we get to look behind that?
We do when the record shows that there was jury and panel December 2nd.
Yeah, but
But he says this is the first available date. We don't know, because there's nothing in the record right now. We don't know why those other cases were set for the 2nd. It may well be that there were perfectly good reasons, and in the absence of a record, we presume that those are good reasons, right?
So yes, and then that would go back to the Burks. Maybe we can't use the bright line. Yes, we for sure had this other trial week available, but then we say, why did they not use the 4 weeks in November, the 3 weeks in January? Instead of setting a show cause hearing for January 8th, why not set it for trial?
But counsel, I guess I still don't understand how those arguments have anything to do with the waiver question. I mean, going back to Justice Land's question, I mean, at the end of the day, we're applying a statute, and it says that, you know, a condition of it is that the defendant was present in court announcing ready for trial. I'm not sure what the trial court's docket management has to do with the question of whether the speedy trial right was waived because of not being able to say that here.
Well, exactly. And as my counsel across the way said, the court does have the ability to control its own docket, but it is limited by statute. It can't.
Well, but I'm asking what that has to do with the waiver question, the question about whether the defendant was
He answered that. He said that the attorney could be in court on the 16th, just not the 18th.
In court, or was going to be in court announcing ready for trial. I'm not sure what that has to do with the court's decision to set it for a particular date. So it seems like two different questions. Maybe there's a burden on the trial court separately to, and there is in terms of giving a speedy trial, but we're not asking about that. We're asking about the waiver piece. So connect those dots for me.
Yeah, what I'm saying is if you show up and say not ready for trial without a valid reason to do so, then that's
Is that what the statute says?
Well, as
What if you have a valid reason for not being ready? You're still not in court
What if
announcing
the court doesn't have a valid reason for not being ready?
ready for trial.
Well,
And
there's
the trial judge's responsibility is to provide the week. It's not to accommodate every lawyer's conflict.
Yeah, but the court granted this Okay, I'm going to stop talking.
So a leave of absence that narrowly tailored is what I'm saying is the exception should be.
Does the record reflect whether or not the case was sounded on December 16th? In other words, did the court call the case and somebody not announce ready for trial, or had the court already removed it from its calendar?
The November 22nd transcript may show that, and I will get that immediately.
Well, I mean, the November one wouldn't, right? I mean, this is I'm talking about December 16th.
So at the November 22nd hearing, the trial court just said, well, we can't go forward because of your leave of absence. So they did set a show cause hearing for January 8th,
nothing happened.
which presumably means they did nothing on December 16th.
Yeah.
All right. Thank you, counsel. Thank you.
That's really interesting distinction. The difference between actually showing up and saying you're not ready, or having the case called and being not ready, versus the court just presuming you won't be ready. That might kind of give the justices a way to get around that issue that Justice Land was pushing.
To both sides for your argument. We will get a decision to you within the 2 terms of court required by the Constitution.
Interesting. Let's see. I used to work for a personal injury attorney in my Navy years. He sent me to court for him one time to ask for a continuance. The judge was not happy. Yes, I can imagine. Oh, man. Okay, so I'm going to take like a 2-minute break, and then I am going to show you this concurrence issued by Peterson pretty quickly. I'm not going to read the whole thing. Just to, I kind of referenced it earlier. I said there's the one concurrence, so I'll just show that real quick. And then, hold on. And then we'll look at the Ninth Circuit case, the John Lewin case. I can imagine judges form opinions about certain attorneys. Yeah, they do. Credibility with the court's really important. I talked about that with like Brian Steele in the what was it? In the wait, can you hear? Okay. Could you guys hear that thing when it was playing? Am I missing something? Get a refill birthday drink? I will. Like clearly you guys could hear it, but I'm just like not sure on my end how you can like not hear. Sorry. I was just looking at the software. I was confused. Yeah, the appeals court argument. I was talking about in YSL. I mean, definitely true. I mentioned that when we watched him last week. But you heard court. Okay. When he was when Thug's sentence, when Judge Whitaker was deciding Thug's sentence, and Steele went through, he just like spoke extemporaneously for like 30 minutes, explaining why why the state's case was garbage, and he just, the judge kind of had to take him at his word that he was giving, an accurate representation of the facts. And I have a ghost. I guess so. That he was accurately reciting the facts and making an honest representation to her. And she clearly, I'm not saying she blindly believed him, but she believed him, took him at his word as to the case pretty clearly. Wait, no, I don't think I have a noise gate. Do I? Should I have noise? Should I set one? Can you guys hear something? I don't know. Anyway, I'm going to take a 2-minute break. I'll come back. I'll show this this opinion real quick. Speed trial. Yeah, it is. Oh, that's true. I didn't even see that, Matthew. I'm going to see that forever now. Ah. Okay. Okay, so just give me like 2 minutes. I'll be right back. And we can continue. All right. Okay, everybody. Let me see. What is my Hal themed break music? Tennessee whiskey, except it's Scotch, so I don't know. Scotland whiskey. This was actually a gift from. I should put this. Hold on, let me mirror this. They get my birthday free Starbucks. I did not. I forgot about that. There's one across this. I mean, there's one across the street from everything, but there's one across the street from me. So this was a gift from. I guess my law firm was a client of a real estate agency because we would have to sell property, like real property, both land and houses on a fairly regular business on a regular basis. So they sent us a gift, and I got it at like 3 p.m. on a Friday. And I hadn't had any food all day, and I'm like, I'll have one drink at my desk because it's Friday, and I was just like trashed after one drink because I hadn't had any food all day, which is pretty common for me when I was working in Big Law. And it was like the end of the day. I'm like, I don't know if I should drive home right now. This is a problem. It was probably a big glass, but you know, yeah, I like Ubuntu. But I actually really like that the real estate group. They were cool. But that's pretty much the only gift you get in law firms is liquor or wine. For my first birthday in Big Law, I got like 3 bottles of wine. And then I think I got EDB, a Chrome. Yeah, I have like a Chrome booster, but I don't love it. No cocaine. Yeah, that's true. I don't think lawyers really use cocaine anymore. I think it's all like Adderall and like Vyvanse. I mean, I know for a fact that some lawyers use cocaine, but not in the way they used to. But I know for a fact that lawyers use Adderall and Vyvanse all the time. I would never do that. Other lawyers. Bottles of Bailey's. Hey, there you go. When I was the first bar I ever bartended at was a place called Bedrock Billiards in DC, and I'd been there for like 20 years. And it was right off that too. It was right off of like this main like party strip in DC. And there was like a neighborhood bar, like a dive, like an actual dive bar, not like a fake dive bar. And we had like this one like Irish whiskey that was terrible, and we all drank it. It actually wasn't that bad. Called Clontarf. It was the go-to there. Everyone drank it. They went through bottles of it just like crazy. Hold on, I'm gonna grab some water. Yeah, I insist that I learned like as much about being a lawyer. I learned more like practical stuff about being a lawyer from being a bartender than I did from law school. Like obviously in law school, you kind of learn how to, um, how to teach yourself stuff and whatnot. But if you can like convince a drunk person that they should go home instead of continuing to drink, like that takes some serious negotiation skills, like argument, being personable, client relations. Like if you can convince a drunk person that they're drunk, you can do anything. The world's your oyster. Okay. So, OBS will let you use. Man, that's complicated. Guy who writes yeah. Oh, that's funny. I was watching some body cam footage. Matthew would like this. I was watching some body cam footage. Was it 2 days ago? I think. And it's outside, and it's on a road as it usually is. It's actually on Cleveland Avenue in Atlanta. It's across the street from 221 Cleveland Avenue. And so there are like cars going by. And in theory, it was supposed to be a random stop, like a non-targeted stop. Like police were just patrolling and they stopped this person. But I was listening to the body cam. I've listened to this body cam 100 times, and I finally heard it for the first time. You can hear the officer that did the stop say he was the main target. because there were a couple of other arrests that day. And so I was playing around with some kind of like audio plugins to try to like isolate that voice. And like I knew he was the main target. It was incredibly obvious from the circumstances of the case. But they swore in court that it wasn't targeted, that it was like a random stop. Just some light perjury. But yeah. I asked Tiffany, Fit Lawyer, like why officers would misbehave on body cam. She said the way a man does one thing is the way he does everything. It's like they act the same way on camera as off camera. There's no explaining it. The way you do one thing is the way you do everything. I saw a bartender get a drunk guy to get the fuck out, and the kind of polite and firm, yeah. I once had a guy. So I worked at this nightclub in DC, and a bunch of Marines. They were like they worked at Arlington National Cemetery, so they all have to be like 6 something and like a certain weight, and so they're like enormous. And there's this one drunk guy who's even smaller than I am. I mean, I'm not that small, and he like really wanted to fight me, and I was trying to convince him that he shouldn't fight me. And then like these 3 Marines were also convincing him like not to fight anybody. And then the 2 cops that were like off duty but like in uniform, you can like pay them to do off duty work basically. It's like quasi on duty. And they also started trying to convince this guy not to fight anybody. And he like literally demanded the police officers arrest him. And the police were like, we really don't want to arrest you. Like, we're not even really working right now. We just want you to chill out. And he ended up eventually getting arrested because he tried to fight one of the cops. That was a failure on my part. But literally, there were like 6 of us being like, dude, just like, you're not even in trouble. We're not even mad at you. None of us have anything against you. We're just trying to get you to like not get yourself in trouble. But he insisted. Oh, man. It's like if the cops arrest the guy, they have to like, do stuff and get him to like actually book him. Normally they're just there to make sure people don't get out of hand. They're cool. It's not something I say about cops often, but they're good guys. Oh, hey, Melissa. Okay. So I'm just going to read. This is Justice Peterson. This is the very elite post. Yeah, it is. They have pretty strict standards on like size and experience and whatnot. They're young guys too. It's crazy how young they are. Not all of them, but many of them. So this is Justice Peterson. This was a case earlier this year, I believe. Just a couple months ago. Oh, 6 months ago. 4 months ago. This is actually, let me show you something real quick. That is the name of the defendant. It's Killian Nelson. This will give me a chance to show you guys something cool. Actually, let me show my screen. This is this one. Let me pull it up for you. I think I've showed this before. Here we go. If you go to Fulton County, you can do like Fulton County Open Data, and you go to this site. I'm not sure which one of these it is, but Fulton actually has like pretty good transparency. Surprisingly. So I think that's why people find Fulton County like doing shady stuff so often, is because they have they do have pretty good transparency. They're like transparently terrible. Let me see. Download the data. CSV files from Excel. Yeah. So this will give you the list of all current Fulton County inmates. Let me switch this up. I'll show you this. Put a filter on this. Oh, wait, no, not this way. This way. So this is oldest to newest. We don't need this. You guys see this okay? Yeah, I think you can. So this is Curly Nelson. If he's out, I'm going to be annoyed. Well, not really, but it would kind of ruin my whole thing here. There he is. So he is the 17th longest, I guess, inmate. I don't know if it's a different term for jail. But he is the 17th longest incarcerated person in Rice Street. He's been there since June 6th, 2020, so 5 years and 3 months. Most of these cases here they're mostly people who are like in and out of like mental health hospitals. Like I know at least like the first I've checked like almost all of these. I think like all of these ones are mental health. So they're like competency cases. They're mostly like in and out of Rice Street, but mostly in this in some kind of a health facility. But I know that Nelson is the one who has the issue with the speedy trial. So this is the person who we're going to be looking at. See if I recognize any of these other names. I think I think he was part of the cash out Rico. I used to know more of these, but some of them have moved on. I think Burwell's had a case. She was involved in a really violent homicide, and I think she's going to get acquitted, and they're just trying to press it out. She was the girlfriend of the guy who did the murder, and she's like involved on a conspiracy. Like she was also involved in theory, but I think she has a case. I think her case is coming up soon. See, I don't remember. Recognize most of these other names. Actually, let's see how many people have been in Rice Street for over a year. Here we go. 474. That's a lot. Okay, what's the total count in Rice Street right now? Let's see. Copeland. 2,969. Yeah. I mean, Rice Street's even more violent than Rikers, which is wild. I was talking to one of the inmates that I DM with, and I was telling him about how there's a report in Rice Street about how they like melt holes in the windows so they can have like drones fly stuff in, and he was like, "Yeah, that's just how you do it." Like, damn, man. He's like, "Yeah, of course, you just like melt the hole in your window, and then you have the drones fly in." Oh man, I love that guy. I really do. He's awesome. Okay, enough about that. Let's go back to the PDF. So that is who we were talking about. William Dante Nelson. So he's been in Rice Street for 5. I don't know if they're legal occupancy, but it was built for 1,800 people. I'm not saying that he did this. He's just telling me like that's what people do. I don't think he's done it. He's clearly innocent, so he's not trying to get in trouble. So that is the case. He was charged with murder in connection with the June 3rd, 2020 shooting death. I think, when was he incarcerated? Did it say June 6th? 20. I'm sorry, play it up. Yeah, he was arrested on June 6th, 2020. Let me slide this over so you can see. Darwin Davis. So this is just the majority opinion. He did it in Minecraft, exactly. No, there are like a lot of cases involving drones in prisons right now. Tiffany had one recently. We like 6. The Mega Motion. God. He dug straight down. Yeah, there have been a ton of drone cases in prisons lately. Like, Tiffany had one. I've seen a couple others. There was one in Fulton County recently where the sheriff found like some mixed sandwiches on the guard line, and so he was like, "This is clearly drones." Anyway, I'm gonna show you the Or are you? Justin Grew disqualified. This is the concurrence. I'm just going to read a little part of it. I joined the court's opinion in full, right, separately to point out that our speedy trial case law appears to have gone astray. Over time, we appear to have adopted too high a standard for the prejudice a defendant who is incarcerated pre-trial must demonstrate in order to secure dismissal of an indictment against him on constitutional speedy trial grounds. So this is different from the statutory speedy trial, which is what was in the video we just watched. You have the statutory right to speedy trial, but that doesn't like vitiate or overcome your or eliminate your constitutional right to a speedy trial. They're separate rights. In an appropriate case, like Demise McMullen's case, which is why I'm really mad at his lawyers, in an appropriate case, we should reconsider that precedent, the logic of which would suggest that there is no speedy trial problem with leaving an innocent until proven, Matthew, you're right, there are a lot of compound words here, innocent until proven guilty defendant in jail without trial for decades, so long as they are not mistreated there. And remember, this was Rice Street. The trial court found that there was no issue, that there was no mistreatment in Rice Street, even though it was a Fulton County judge. The U.S. Supreme Court has identified three interests the constitutional right to a speedy trial was designed to protect: to prevent oppressive pretrial incarceration, to minimize anxiety and concern of the accused in Rice Street, and to limit the possibility that the defense will be impaired. Barker v. Wingo. These are the two cases you obviously cited in speedy trial cases, Barker and Doggett. Man, I'm really sad that I didn't get to work on Demise McMullen's case. He deserved to have his case dismissed in the YSL case. It's actually one of my most watched videos, surprisingly, is the Demise McMullen video. He's the one who never had a lawyer for like several years in YSL, and the state was sending the notices of hearings to his home address when he was in prison. So anytime they needed to notify him of a hearing, they would send it to his home address where he hadn't lived in decades. And anytime they needed him to be produced for court, the state would get his address correct so that they could have him produced to court. And he didn't have a lawyer for several years. I think it was like 4 years. It was egregious. That case absolutely could have been dismissed. Did he turn down your help? No. When he got a lawyer recently, well, he got one. The one that like was trying to get off the case. And I talked to him briefly. But he then left the case. And then the new lawyer, I never talked to him. The one who pled him out. I wish I had, though. It's kind of like Sledge's case. I wish I'd like gotten involved in that sooner for obvious reasons. It's also made clear that prejudice to a defendant caused by delay in bringing him to trial is not confined to the possible prejudice to his defense. I apparently highlighted stuff. There's some evidence that as a matter of original meaning, the speedy trial right primarily protects the accused from a prolonged detention without an adjudication of guilt. The Supreme Court has expressly rejected the notion that an affirmative demonstration of prejudice is necessary to prove a denial of the constitutional right to a speedy trial. So just having too long of a trial is sufficient. Can be sufficient. And I'm not going to read this whole thing because it's quite long. I almost did a whole video on it, but the whole opinion's quite lengthy. But I'm going to show his conclusion. The last paragraph. When the issue is properly presented, we should examine our precedent regarding what is necessary to show prejudice for purposes of the factors relating to the right to a speedy trial or the violation of that right. In the meantime, whereas here the case is yet to be tried, a remand for a new order, such as that reissued today, further delays the trial of the case. That means that a defendant who stands merely charged, not convicted, continues to sit in jail. And in evaluating the presumptive prejudice that is caused simply by the passage of time, courts look to the total elapsed time since the speedy trial rights attached, and that time is increasing with every passing day. Thus, any delay in the issuance of a new order itself may strengthen the case for dismissal. See Williams versus State. I think I cited that recently for a different reason. In short, after this case is remanded, time will not be on the state's side. Citing to Ruffin, noting in affirming denial of motion to dismiss on speedy trial grounds that the clock is still ticking and any further delay in bringing defendants to trial not attributable to defendant runs a serious risk of violating defendant's right to speedy trial. Yeah, I definitely will, James. I actually wrote it down. But that's just general context for the last video that the Supreme Court in Georgia is clearly unhappy with the state of the right to a speedy trial, both statutory and constitutional. And yeah, James, I'll definitely listen to it. I think you mentioned it last time or the time before that. I remember you mentioning the Terry case. So now I want to show this one case. Let's see what I want to show first. What should I show first? Let's watch the oral argument first. So this is the John Lewin case. John Lewin was the trial prosecutor in this case. And it involves the hiding of evidence, or not hiding necessarily, that's probably too strong. But sort of a refusal to allow all of the evidence to be let in by John Lewin. And so we're going to listen to this. This is Ali Ockelson on the bottom left. He represents the defendant. And so this case is going to come down to withholding. Yeah, that's probably... It wasn't withholding. Everybody knew about it, but he got it excluded. Basically, it was a cold case, and there were... I'll give you a little bit of background. This is a murder case. The defendant was convicted. It was quite a while after the murder had occurred. And there was another suspect named... his last name was John Russo, Gianrusso. But he had died, and so the prosecutor, John Lewin, basically got a bunch of evidence related to that other suspect excluded, because I don't know why. And after he got the evidence of the other suspect excluded, he argued that there was only one suspect, that there was only one person who could have done it, after he excluded all the information about the second suspect. And the guy who's convicted was one of the two people who saw the victim last. And the guy who's John Russo, he was the second guy, and Lewin basically got the second guy out. He died from all this shit. I don't know how he died, actually. But so this is Al Yockelson. He was deep in the Twitter comments during the ASAP Rocky trial, which I loved. And I don't know this guy, but I've written. Oh, actually, no, I've been to this courtroom. I had a case in this. I had a Ninth Circuit case here, the Pasadena courtroom. None of these judges were there. Different panel. I didn't get to argue it. The senior associate did. It was funny. It was the senior associate who's like my age, and the guy arguing the other side was the former Solicitor General of Illinois. And he was like this old, distinguished legal guy, and the guy on our side was like 30 and had like a scruffy beard. It was really funny. Anyway, the court ended up remanding for further proceedings on a completely separate issue that neither side argued, so nobody won and nobody lost, after we'd collectively spent like $1 million briefing the issue, and they settled after that. So it was a totally useful, great use of resources. But okay, let's check this out. And I've never seen this.
Yes, good morning, Your Honors. Alan Yockelson on behalf of petitioner Douglas Bradford. I hope the court was able to hear all of what was probably the most brilliant oral argument I've ever.
Can you guys hear that okay? What's the audio like?
But I do want to thank the court for advancing this on the calendar and apologize to counsel who are waiting. As the court was told, my flight was delayed yesterday, which wouldn't allow me to get back to California
I think he's from San Diego, but he must have been out of town.
in time, and the hotel wants my room. So thank you for indulging me.
This courtroom used to be a military hospital. It has a really, it's kind of like an odd looking structure. It's really nice inside though, but it's a building that doesn't look at all like a courthouse.
This case, I understand, is the limits to the issue to which a certificate of appealability was granted, limited to third-party culpability, and that the court may or may not expand that to address third-party culpability with regard to Ms. Juarez. But
I think before, at least for my part, you can argue both of them. Because we did ask for briefing. Whether we're going to grant the certificate of appealability will.
What do you guys think about the Zoom backgrounds here? I don't really like the all white.
Yes, thank you, Your Honor, and I am prepared to do both. But before I launch into that, I think it's really important to understand the background of this case, a 35-year-old cold case of murder.
I'm not going to say that. The more of this I have, the closer I'm going to come to saying something I shouldn't. So let's drink more and see what happens.
Case that was first an attempted strangulation by a garrote.
Okay, I was smiling while he was saying that. I got to do that again with me not smiling.
Was case of murder case that was first an attempted strangulation by a garrote and then a stabbing with what was apparently a weapon of opportunity. And yet there was not one shred of forensic evidence linking Mr. Bradford to that crime scene, to the...
Bradford is... Okay, we can watch Cat Lawyer at the end. I'm always down for that. But Bradford was who was convicted, and he's still alive and is now, I believe, now free.
Decedent's apartment, a place where, under the prosecution's theory, Mr. Bradford was that night, which they never proved other than circumstantially, and where he had been on many other occasions. One would have thought...
What do you mean they never proved other than circumstantially?
So the guy in prison had previously dated the victim, so he had they could find his hairs in the apartment. So it wasn't finding his DNA in the apartment would somehow be, would be, necessarily incriminating. Like they had my understanding is that they were still engaging in relations from time to time.
Substantially.
But he was at the scene
This is basically the plot of Shawshank.
Night. There was no forensic evidence to suggest that he was at the scene
that
night.
He was there. He told the investigators that he was there.
Oh, no, I'm talking about Mr. Bradford.
Oh, I see.
Mr.
Okay.
Bradford, Mr. Giarrusso, certainly, I guess the point I was trying to make is that if you look at the entire background of the case, what you see is anytime evidence was favorable to the prosecution, whether it be the wire evidence or profiling evidence that came in under the guise of crime scene analysis, Judge Rapay was quick to point out that went to weight, not admissibility. It was for the jury to decide.
I'm so tired of hearing that.
But when the evidence was favorable...
That's fodder for cross-examination.
To the defense, such as the third-party culpability evidence, then it was a matter for the judge to rule on as a matter of law. And in this case, I felt a little bit like Charlie Brown to the court's Lucy, because we had extensive argument on the admissibility of third-party
By the way, I love this judge's earrings.
culpability evidence, and especially with regard to Mr. Giarrusso. And at the end of the first round of argument in limine, the court challenged me because it's rare, but I was actually involved at the in limine stage of this case along with Mr. Dennis Fisher, challenged me to bring to court a case that showed that a 3-hour time difference between the murder and someone being at the crime scene was sufficient to, under People versus Hall, to admit such evidence. And so I went back and I did that, and we filed supplemental briefs, and I found more than a dozen cases nationwide and through federal jurisdictions as well, and was briefed, it was argued, and at the end of the argument, Judge Rapay says, "Oh, Mr. Yockelson, you didn't bring me a California case." Well, the football was was taken, and there I was, Charlie Brown, because no, I did not bring a California case, but I brought a dozen other cases that stood for the same proposition.
Is your position is not just because he was there 3 hours before. There is some other evidence. There's nothing specific, but as you say, there's more with regard to Mr. Bradford, but there's nothing direct. It's all circumstantial with regard to him as well. Exactly.
Does
that make a difference? One thing I've been wondering about is, does it make a difference with regard to the admission of third-party culpability evidence, what the state of the evidence is with regard to the defendant, comparative? I know there's at least one case that says, well, the Supreme Court said you can't do it the other way. You can't say, well, the prosecution's evidence is so strong that you can't let in the third-party culpability evidence. What about if the prosecution's evidence against the defendant is of a certain kind, as it is here? Does that affect whether the third-party culpability evidence comes in?
I think it must, Your Honor. I think we're looking at a continuum. As the court is referencing in Holmes, the issue was they had DNA evidence, and the Supreme Court in Holmes for South Carolina said, we don't care how strong the prosecution's evidence is. If it's not challenged and not conceded by the defense, then the defense has a due process.
I think senior judges have a decent amount of activity in the Ninth Circuit. I believe one of these judges, if it's not this one, there's another Ninth Circuit hearing in this case where one of the judges was sitting by designation from Florida, I think. I believe it was a Florida District Court judge who was flown out to sit on the Ninth Circuit panel.
Process right, a confrontation right to challenge that evidence. And here, I think that I know how deflated we were pre-trial because we thought that third-party culpability evidence was everything in terms of defending this case. And that was entirely because this was a circumstantial case, and the prosecution had a field day here with Mr. Bradford trying to go back and prove up a 35-year-old alibi that he was out sailing that night. And it totally shifted the burden in this case. And as I noted earlier,
the prosecution say something at the beginning. This doesn't seem to have been discussed, but the prosecution said something at the beginning of the case about how nobody was in the house that day. But that's not part of your argument here, as I understand.
Oh, yes, it is, Your Honor. It's in the briefing and it's in the record that's exactly what, not only did the court err in not admitting third-party culpability evidence, but it gave the deputy district attorney license in opening and in closing argument.
John Lewin is who he's talking about.
District attorney license in opening and in.
Actually, now that I think about it, the judge that wrote our opinion in our Ninth Circuit case, he was a senior judge. He came to the conclusion that I did in the internally discussing it in the law firm. Shout out to that judge. I can't remember his name.
Give the deputy district attorney license in opening and in closing argument to say not only that nobody was at the crime scene that night but Mr. Bradford, but it also gave them license to say that he specifically picked that evening because he knew she would be alone.
Think about that. That's what John Lewin argued. That's what I was talking about in the intro. Jean Rousseau or Jean Rousseau was with her that night. And irrespective of whether maybe Bradford did it, maybe I don't think he did. It seems like it was probably Jean Rousseau. They're not going to talk about this because it's an evidentiary thing, but during the trial, there was a description of the person who probably did it, and it matched Jean Rousseau and not Bradford. So there actually is probably stronger evidence that Jean Rousseau did it as opposed to Bradford. Do we think they're wearing pants? They better not be. I wouldn't be. So yeah, that's the issue with Jean Rousseau. I don't think it's enough. There would have been enough to convict him either. It's kind of like Wolfenbarger in a way, where it was like there was. I don't think the dad did it, but where it was either like the boyfriend or the husband, and like there's some evidence for both. But it would be like Wolfenbarger if they couldn't enter evidence about the father or the boyfriend.
And that was totally untrue.
By the way, I have a big project I'm doing on Wolfenbarger, and I'm super excited about it.
Were those statements challenged at the time?
I cannot tell you right now whether I know, because I was not present during trial. I was only engaged for pre-trial, and so.
By the way, I absolutely love Ali Ockelson. He's fantastic. The dry sense of humor, the pettiness on the internet. He's like, if this were like my father, I'd be proud.
And then I was retained for this federal habeas. In between, he had either Mr. Shapiro or other appointed counsel on his state appeal. So I don't know, I can't honestly say to the court right now whether that was objected to, but I do know that the motion in limine was re-raised at trial, and that it does appear in the appellate briefs in the state court.
It was raised ad nauseum. I mean, if the question is whether it was preserved, it was.
He's pissed. He's got that stew. He's like that anger that just boiled over. I love to see it.
Here in the appellate briefs in the state court.
It was raised ad nauseum. I mean, if the question is whether it was preserved, it was addressed pre-trial, and then page after page of a huge transcript that was covered and recovered. And the judge relied on his understanding of 352 as being ironclad, and based on his understanding, he excluded the evidence.
Did you hear the way he said his understanding? Based on this idiot's understanding.
He relied on his understanding of 352 as being ironclad, and based on his understanding, he excluded the evidence.
Yes, Your Honor, you are absolutely right. Every time some new incident occurred at trial, whether it was opening statement, whether it was the coroner, Dr. Carpenter, who had passed away, and his assertion in his report that.
Okay, I'm gonna let it play for a bit after this, but he mentioned these. I meant to jump in earlier. He said something about the sailing alibi. That was Bradford's alibi. But he was from, I believe, Santa Monica, which is on the ocean. It's a terrible place. And his alibi was that he was sailing by himself at the time of the crime, which made me want him to be convicted. But nonetheless,
the time of death might have been. Or that the digestion of the Chinese food might have occurred at a time that would have been inconsistent with Mr. Giarrusso's claim that he was that he had left the apartment, thereby narrowing that 3 hours even further. Every time a circumstance like that arose at trial, I know there was a motion renewed to admit, and in fact, I believe it was, they opened the door was one of the comments of defense counsel to ask the court to reconsider its in limine ruling.
Two things, because you're going to run out of time soon. One is Brecht and harmless error, which seems to me to be very important. And the second is how it applies to this.
Yes, Your Honor. I don't think under the circumstances of this case, this could be deemed harmless error. Again, as I noted, there was nothing to connect.
What about the very firm and repeated alibi evidence from Mr. Giarrusso? Does that matter? Can that come in? Is that even relevant to us now or not?
I don't believe so, Your Honor, because again, the question really is what is a jury allowed to hear? What should the jury have heard?
Well, I know, but if you thought that his girlfriend's alibi would come in and that she would say, as she said, both then and at the time of trial, or close to it, that he was definitely there by midnight, and wouldn't that mean that in terms of harmlessness, not in terms of or Brecht harmlessness, that it was unlikely to have made a difference? Or would it have? Or can you even worry about that with as you apply Brecht? I mean, it seems to me that there's a question about how much outside the record you could go, because you don't really know what cross-examination would have shown about that alibi and what if it were investigated, what would show up and so on. So do we take it into account even, is what I'm asking you?
I don't think so. And I think that we come back to Holmes, where this is untested prosecution evidence because of the rulings that were made. And I don't know how you can get around the untested and non-conceded facts that the prosecution brought forward and determine that under those circumstances, Mr. Bradford had a fair trial in this case.
And then finally, and because it's paid very little attention to in your brief, what do we do with with EDPA and the 2254D1 standard or 2 standard? Which one applies and why is it not dispositive here?
I believe this is an unreasonable application. I know that the state has pointed to a footnote in Holmes where they seem to indicate with favor People versus Hall is an instance where the state got the analysis right in Hall. And I would caution that we have seen divergences, not in cases themselves, but in application of cases. And it calls to mind a death penalty case that I had in California, where the main issue was that Wheeler and Batson versus Kentucky, which were all on all fours with each other.
Talking about Batson now, I love it. Ooh, I should do a video about the Curtis Flowers case. I need to add that to my list next to the 5-4 podcast.
When they were decided, California had so diverted in Wheeler from the dictates and mandates of Batson that the U.S. Supreme Court was forced to take California versus Johnson to put.
I will add that California has a reputation kind of nationally as being soft on crime. And there are like specific jurisdictions where that's true, but by and large, it's actually an incredibly punitive state as far as the criminal justice system goes. Actually, this goes back to like Kamala Harris. If you talk to like a lot of the like criminal justice reform, Innocence Project people in California, they loathe Kamala Harris based on some of what she did in her time as the AG as the state of California. But California, by and large, is incredibly punitive.
California back on the road. And I think what happened
significantly more punitive than some of the states that you would think of as being harsh on crime
is that there's no problem with the Hall analysis if it is applied in a way that is consistent with Holmes. But it wasn't in this case, so it was an unreasonable application.
All right. Well, your time is just about up. We'll give you a couple minutes to rebuttal. Thank you.
Thank you, Your Honor.
Did they just add time to his clock?
Mr. Rebuttal. Thank you.
Thank you, Your Honor.
Look at this guy's face. He's so mad. I love it.
Cooper.
Good morning, and may it please the court, Deputy Attorney General.
Bro, this microphone. You're appearing before the Ninth Circuit. What are you doing?
Mikhail Cooper for Respondent Appellee. Just to, I guess, start at the outset.
Yeah, James, that's kind of what I'm talking about. Kind of the same idea. Also, some of her like evidentiary disclosures are questionable. And I'm not saying that as like a Democrat-Republican thing. I mean, I think that criminal justice reform, and you see this in like the YSL case, in the Karen Reed case, really any major case, you'll see, people that are both either liberal or conservative coming together. I think criminal justice reform is one of the few issues that people in the U.S. are really bipartisan on. I know, like, there's a perception every time there's a major case, like in the Karen Reed case, we were all thinking, "Oh my God, everyone's coming together. This is unique." In the YSL case, we said the same thing, but really, I think that there is bipartisan support for criminal justice reform. So when I mentioned Kamala Harris, I wasn't trying to, make any statement other than that she wasn't particularly well liked in California criminal justice reform circles. And certainly I do have my political opinions, but I try to keep them to myself because this is kind of my criminal justice reform is kind of my issue that I've chosen to focus on. And I really do think that there can be bipartisan support. In a lot of state legislatures we've seen, like in Virginia, back when I lived in DC, I know in Virginia there was a big bipartisan push for criminal justice reform. And it was led by the most conservative guy in the world and the most liberal guy in the world. So dividing lines for what kind of criminal. Yeah, there's some truth to that. I think that criminal justice reform in the abstract can be less popular for people. But once they see a specific case, it tends to become more popular. I think that's what the Karen Reeds and the YSLs of the world do. Once you actually see the justice system in action, you kind of get a distaste for some of the things, some of its aspects. But I mean, in the abstract, you're like, yeah, people, should be punished harshly. They're criminals. They don't deserve X, Y, and Z process. But once you actually see it play out, their opinions often change. Aaron says the very same people who are criticizing bail reform. Yeah, totally. I have a hot take on bail reform. I'll probably save it for another. I'm going to add it to my list, actually. I think bail as a concept makes no sense. Just fundamentally. Not even pro or anti bail. It's just as a concept, it doesn't make sense. Not even a does it work or doesn't it work thing. It just if you really think it through, it just as a concept doesn't make sense.
Just to, I guess, start at the outset, the procedural posture of this case is important. The court cited EDPA, and I think that's correct. We're not here to relay the trial court's evidentiary rulings under California law.
I hate when they do this. I actually, I can't say this. I was going to say something about Tounk's appeal, but I really don't like it when the defense lawyer says the state did these 16 evil things, and the state's response is, there's a procedural thing here. Shut the fuck up.
No, this case is governed by EDPA, and it issues the state appellate court's decision, basically affirming the trial court's ruling. And the question is whether the state appellate court on direct appeal correctly or incorrectly applied clearly established federal law. And it's clear here, the clearly established federal laws, Holmes said that.
Look at his face. He's so mad. Oh, you love to see it. Look at her face. Oh, this is not going well, my friend.
You can't solely look to the strength of the prosecution's case when excluding third-party defense evidence. And that's not what the state court did here. Holmes also approved of Hall, and that's what the state courts applied.
Well, wait. When you say they approved of Hall, is that big footnote where they just cited every case? Well, I don't think that's an approval of anything. It's just saying a lot of states, a lot of courts.
I feel like he's going to explode. I haven't watched this, but I feel like he's going to have a moment to cook during these coming 13 minutes and 55 seconds.
Well, I don't think that's an approval of anything. It's just saying a lot of states, a lot of courts have done this. It doesn't say anything about whether the details of any opinion are correct. I don't think anybody's.
Okay, I'm sorry. Look at look over here.
On this, it doesn't say anything about whether the details of any opinion are correct. Courts have done this. It doesn't say anything about whether the details of any opinion are correct. I don't think anybody's saying there's anything wrong with Hall, but I think saying there was an approval is a little much.
All right. Well, in this case, the state courts applied Hall, which calls for examining the defense evidence and seeing if they're in the defense evidence, if it just provides evidence of motive, evidence of opportunity, and saying that's enough. That's not enough to admit third-party culpability evidence. What is enough is if the third-party evidence points to the actual perpetration of the crime by the third party, and it's beyond dispute here. There's no direct link between Giarrusso or Juarez to the actual perpetration of the crime, and so it's a very simple case. Yes, Your Honor.
But counsel, what do we make of the fact that at least initially Juarez was identified by an eyewitness? Didn't that link him to the crime?
No. Well, here's why. Because Juarez wasn't actually identified in the sense that.
Thanks for coming to Factual Eye. By the way, what time would be? I'm separately from what we're going on. What would be like a good time for me to stream? I'm never sure what time to do. It's mostly like it's gonna be late for Factual Eye or like the UK no matter what. If I did like 2 o'clock my time or 5 o'clock Eastern, that'd be what, 11 o'clock UK. I just don't know whether to do like during during 9 to 5 on the East Coast or later. But if you guys have any opinions,
actually identified in the sense that this is what happened. The witness saw a shadow of a man flee from behind in the dark from 70 feet distance for a matter of seconds. When he was brought to Juarez, he was detained about a half mile away 20 minutes later. He couldn't identify him from the front. When Juarez was turned around, all that Valeri said, that was the identifying witness, all Valeri said of Juarez was, that looks like the guy, it possibly could have been the guy. And then also you take into account that the circumstances of the ID were pretty weak to begin with.
Didn't police use that identification to take Juarez into custody?
Yes, and then he was never charged. And the reason is because there was no evidence linking him to the actual perpetration of the crime. And he had no motive. He did not know the victim at all. Also, years later in 2003, Valeri recanted that identification he made of Juarez. He said then, I was eager to help police because the victim was someone he knew and was close to. And that even though, I went to the show up.
He did.
This all goes to weight, as courts love to say.
And that even though, I went to the show up.
He needs to stop talking sooner. When a judge starts talking, justice starts talking, you stop talking. He's spoken over judges twice now. That's not something that's going to go over well, especially when they're clearly unhappy with you and unhappy with the case in general. Like you're asking them to decide something that's clearly fucked up in your favor on procedural grounds. Don't talk over the judges.
And that even though, I went to the show up.
He did describe the person, and he's
good point,
described him quite consistently as having black curly afro-like hair.
Yeah, that's the part. That was the matching description. The person said that he had curly hair. Yeah, I don't compete with them. I blow them out of the water. Fuck out of here.
Is having black curly afro-like hair.
That was the description of Gian Russo. He had curly hair.
Described the person, and he's described him quite consistently as having black curly afro-like hair, and
what was that? Yes, they did describe Gian Russo to a T.
For example, the California Court of Appeals says that the Caruso did not in any way match the neighbor's physical description, but neither did Bradford.
And neither did Juarez.
I'm sorry, what?
No. Well, no, Brad, he did say
Bro, how do you not have better sound than this?
2010 that the person that he saw.
Well, in 2010, but earlier, he made really clear several different times, as I understand it, that this person had curly black hair, which neither Caruso, I think Caruso maybe did, I don't know, but Bradford definitely didn't.
I could be wrong if it matched Gian Russo. What is afro-like hair? Yeah, I don't know. It was a long time ago.
Well, Juarez had curly hair, but Juarez did not match for Larry's description.
But that's not what I'm asking you. I'm saying that Bradford definitely didn't.
I feel like all three justices are not thrilled with this guy right now. One of my first moments when I was in Big Law for the first time was like the first week. The front desk called me, the front desk of my law firm. Like the app that we have, it's like a phone. It's an app on your phone, but it's like a phone call. So you can take incoming calls in from outside of the firm, like through this app. It's like kind of a Wi-Fi system. And I was in the bathroom and I got a phone call. I was literally on the toilet and I'm like, oh my God, I get it. So I stood up from the toilet and I got like the flushing was going on in the background because it was auto flush and I didn't realize it. So as soon as I picked up the phone with like reception, it was just like a toilet flushing in the background. I'm glad that I Am Shout came up just for that moment for me to explain the intricacies of taking a phone call in the bathroom. It's great timing on my part. The receptionist was kind enough to pretend it didn't happen. I don't think he's literally in a bathroom, but he does sound like it.
I think Caruso maybe did, I don't know, but Bradford definitely didn't.
Well, Juarez had curly hair, but Juarez did not match for Larry's description.
But that's not what I'm asking you. I'm saying that Bradford didn't match the description. I mean, what is now being said is the real usefulness of Juarez was to bring in the description and the fact that
no, I don't think he is. He's definitely taking a dump in his case, though. My God.
The fact that Bradford did not match that description. You say in your supplemental brief that something.
Don't speak. I know what you're thinking. I don't need. Okay.
Of that nature did come in. What exactly came in?
Well, it came in shortly before Larry was to testify. The defense was asked, okay, the defense asked basically use Larry's identification of someone fleeing with black curly hair. They wanted to use that evidence to point to the client and say, our client did not have that hair. And they got that evidence in. In fact, they got more than that evidence in, and it had to be struck. They got in, they initially wanted to identify Juarez by his photograph. They wanted to name him. They were not allowed to do that. Nevertheless, they kind of went beyond the scope of permitted questioning. And they got in more than just the fact.
Okay. Here's what I dislike. I mean, there's a lot I dislike. He's saying they got in evidence like they were privileged to get in evidence. Like, oh, the court, they bent over backwards by letting the defense get in evidence. You should, how dare they ask to get in even more evidence? Yes.
They wanted to name him. They were not allowed to do that. Nevertheless, they kind of went beyond the scope of permitted questioning. And they got in more than just the fact that Roleri saw someone flee with black curly hair. So
I love her. She's fantastic.
in this case, it's not the case that they were denied that defense. They got that evidence in. It supported their alibi defense. It supported their ID defense. They were not denied that defense by excluding evidence of Juarez or Giarrusso here. So I think that's important to note.
Did they get in Roleri's statement that the person who left had black curly hair? Person he saw fleeing?
He saw someone fleeing that had black curly hair. Now, I think later on in his testimony, he equivocates a bit. He said, years on now, I can't be that sure any longer at this time, but that was my initial identification. And the defense.
Okay, it's been 35 years, and the guy's like, I think it was black curly hair, but I'm not sure. That's not good for you, but you're acting like it is.
Was able to argue that.
But the defense wasn't able to argue that some individual was identified by Roleri as meeting the description from the back, from what he saw of the person fleeing. That was not allowed to come in.
Stop
right?
speaking.
That was not allowed to come in because it did not meet the standards for admitting the third party.
The prosecutor said
He's doing it again. Stop speaking. The second they start speaking.
he also say something about nobody wasn't there, said
Again, this is John Lewin she's talking about. I don't know if it is the lag, though, because he's responding quickly, to questions. I don't know. You guys are probably right. That's a good point, James. I just don't like this argument, and I'm probably being biased. And by probably, I mean definitely.
Did not meet the standards for admitting the third party.
The prosecutor said, as I said before, that nobody had been there that night, and that wasn't true. Did he also say something about nobody was something that related to Juarez that also wasn't true? What was that?
I would push back against the first point. I think what he said is no evidence that someone else was there at the time that she was murdered. I know it's in it's an objection made.
No, I thought he said something like he purposely chose this night because it was the one night she he purposely chose this night because it was the one night she had nobody else in the house.
Well, I think that's a reasonable inference from the record. I mean, Bradford was seen at the house a week or two before the murders.
Somebody else in the house.
Russo was at the house.
Russo was at the house for dinner, and then he left at 11:50. As Your Honor
Yeah, that means that the second person was at the house. I hate him.
pointed out earlier.
But the statement was that she had nobody that was the one night nobody was coming to the house.
Exactly. I'm sorry.
Which isn't
Well,
true.
again,
It isn't true.
as Your Honor pointed out earlier.
But the statement was that she had nobody that was the one night nobody was coming to the house. Which isn't
Well,
true.
again,
This isn't true.
well, first off, the issue before us is whether there was sufficient evidence to admit the third-party evidence, not whether at the end of closing or at some other time the prosecutor misstated.
Well, but it's pertinent to
Is he really saying, the prosecutor lied, but that's not before the court? If that's your argument, come on.
The issue before us is whether there was sufficient evidence to admit the third-party evidence, not whether at the end of closing or at some other time the prosecutor misstated.
Well, but it's pertinent to the importance of it, at least. That is, that the prosecutor bothered to say that, suggests that it mattered whether somebody was at the house. It would matter to the jury, or he wouldn't have said it.
Well, again, because I don't think counsel or I know that specific part of the record that the court is referencing, because that's not the certified issue.
All right, so
Okay.
what, the Court of Appeals, whether it's reasonable or not, first of all, was wrong when he said Jerusalem did not in any way match the neighbor's physical description. I don't think that's true. I think Jerusalem did have the curly hair, but I'm not sure. But neither did Bradford, so that doesn't seem pertinent at all. And then they go through a set of other circumstances and say, for example, that the fact that he went...
I'm shocked. This case is So Douglas this is a habeas. Daniel Paramo is probably the sheriff or something in the county where he's being held. This is the case that John Lewin, who is the prosecutor in the ASAP Rocky case, tried and was subsequently reversed because Lewin basically essentially hid evidence. It was a cold case. Like decades had passed between the crime and the trial. And Gian Russo was essentially the alternate suspect, but he had died. And so Lewin basically got a bunch of stuff excluded about Gian Russo. And then at trial, he said that there was only one suspect, which wasn't true.
Hit night while they dated was not admissible, even though it was admissible with regard to Bradford, that he had other physical interactions with this woman. Is that right?
No, Your Honor. So here's why. First, your first point that you think this. No, Your Honor. So here's why. First, your first point that you think the state appellate court misstated that Giurasu didn't match. Giurasu didn't match because he didn't fit the body. He was.
No, that's not what they said. They did not in any way match. So that's wrong.
Okay. Well, the evidence that was before the trial court was.
This is far more adversarial than you will typically see an appellate court case be. There's rarely about the facts, but this judge or justice has clearly taken an interest in this guy. I think the other two have as well, but she is clearly unhappy with the handling of the case, just on a fundamental factual level, which usually isn't the case. It's usually more questions of law, but she's unhappy.
Giurasu didn't match. Giurasu didn't match because he didn't fit the body. He was.
No, that's not what they said. They did not in any way match. So that's wrong.
Okay, well, the evidence that was before the trial court was that Giurasu did not have the body type that was seen by Rolieri fleeing the house.
But we're reviewing the California Court of Appeals decision. That was their determination.
And it's supported by the record before that, because it's not just the hair evidence, it's other evidence too. Because Rolieri gave a description of someone that was leaner than Giurasu, that someone was a bit taller than Giurasu. And eventually in 2010, he said this looked like Bradford. So that was, again, part of the evidence that the trial court was looking at. Number two, both in this court's case law and in the state court, in California case law, a history of violence between a third party and a victim is, without more, not sufficient to say that this third party is tied directly to the actual perpetration of the crime. I think that's reasonable in this case because we don't really know what that incident was between Giurasu and the victim years before when they dated. We just have one mention of that in the record, and that's it. And there's absolutely nothing that ties that incident, whatever it may have been, to the actual brutal and horrific murder of Knight several years later.
Counsel, on that point, what was the evidence that the state had against Mr. Bradford? Tell us the sum total of the evidence that was introduced.
It's a trap
against Mr. Bradford.
Well, it was a lot of circumstantial evidence, but it was sufficient for the jury to convict.
What was it specifically? Specifically, what was the evidence?
Okay, first off, there was a brutal and kind of butchered victim at the crime scene. Bradford had motive.
But that's not the fact that someone was murdered is not evidence of who murdered.
Oh, that was A+ work. I'm sorry.
Specifically, what was the evidence?
Okay, first off, there was a brutal and kind of butchered victim at the crime scene. Bradford had motive.
But that's not the fact that someone was murdered is not evidence of who murdered them. So tell us what the evidence was that connected Mr. Bradford to this brutal murder.
Sure. So because the body was so butchered and it was a bloody crime scene, there was a crime scene analyst who opined that given the state of the body, this was a murder motivated by interpersonal conflict pre-existing interpersonal
This is pure speculation.
conflict and was meant to punish the victim. That's where the motive gets in, because she had just broken up with him. And he had just shown up at her house the day after she did so and hurled a lamp at her and called her a whore.
Not just.
Also,
how long was it?
How long was what?
It wasn't just. It was several months, I think.
She had broken up with a month before, and the day after she did that, he showed up at her house uninvited, found her with another man, threw a lamp at her, called her a whore, and sped away. He was seen a week or two before the murder, kind of lurking and stalking by the house at the
and not killing her.
Crime scene itself. There were two bits of evidence. One, he had given her a necklace, which was missing, and no other personal item. It was that necklace that was missing.
That's what you. Okay, did she? I mean, they'd broken up. Did she throw it out? They were on a break, exactly. So she threw out the necklace that her ex-boyfriend gave her. That's one. Let's see what two is.
Crumpled in her trash can was the invitation to her sister's wedding.
Bitch, are you serious? That's what you're going to give me? She threw out a wedding invitation, and a necklace that her ex gave her was no longer with her. That's what you have. And you're saying it like this is like gotcha evidence. He 3 and 4 better be fire.
She was the maid of honor to that wedding. She planned on going with Bradford. Bradford had thought of Knight as the love of his life. She would have never crumpled and thrown away that wedding invitation.
How the fuck do you know what wedding invitation she would have or would not have thrown out? You never met this person. How do you know? That's what you have? This face right here. Exactly. What are you doing? Do you not know that you're on camera right now?
The love of his life. She would have never crumpled and thrown away that wedding invitation. That wedding invitation was in
the trash can. That is really unusual evidence. I mean, who knows what people crumble? I mean, she read the invitation. Maybe she didn't need it anymore. I mean,
I'm tired of going to weddings. It's expensive. I don't know these people.
What people crumble. I mean, she read the invitation. Maybe she didn't need it anymore. I mean, that just seems. I understand they had testimony that she wouldn't have done it, but it's very strange evidence.
But it's not. That's not all, Your Honor. There's more.
You were explicitly asked what the evidence is.
Here we know that the petitioner, when he was broken up with in 2009 by his latest girlfriend, he displayed similar stalking behavior. He showed up unannounced. He would bicycle from miles away. He joked that he was stalking her.
Did he kill her? Because if not, that doesn't help you very much.
And also his alibi was ludicrous.
I mean, that's the other thing that troubles me, though. So that evidence comes in against him. But with regard to Giarrusso, the fact that he was apparently violent with her earlier couldn't have come in, you're saying?
Well, Giarrusso it's different evidence. It's different evidence.
Yeah, when you have different suspects, you have different evidence. That's just how reality works.
But it's still weighed under the 352 standard, because even third-party evidence has to satisfy the more prejudicial than probative, more probative than prejudicial standard. And so even if you could make the argument that
we just got a face there we need to say
standard, and so even if you could make the argument that some evidence of violence between Giarrusso and Knight years before was probative of the fact that he might have murdered her, it was still highly prejudicial evidence, and there was nothing really probative in that evidence to tie him to the actual murder.
Well, but looking in isolation, but you also have to look at the fact that Giarrusso was the last person seen at the home.
That is true. Gianrusso, I don't know how to say his name. He was the last person at the home. Bradford, I believe, had dinner with her in the apartment. I could be getting this wrong, but I believe Bradford had dinner with her in the apartment, and then Gianrusso saw her later. So Gianrusso would have been the last person to see her alive. To be fair, Bradford did supposedly have a key to the apartment, I believe. I haven't looked at this since the A$AP Rocky trial, but I believe that was the case.
Other than the victim. So it's not just that isolated evidence. Just like with Mr. Bradford, it would be a series of circumstantial evidence. And it's not just that one piece. It's also the piece that he was physically observed at her home shortly before she was murdered.
What's that mean? Yeah, he was the last one to see her alive. So Bradford would have had to like be at her apartment, leave, and then come back after the other guy, but before the murder, obviously.
Right, Your Honor, but the difference is that it only gets all the evidence against Geruso only gets you to he had an opportunity.
He also had Geruso had a cut on his
That's all you have for the other guy.
Finger, and there's something that says, well, that couldn't have been it because he was wearing gloves. Well, I mean, that seems to me to be exceedingly weak as well. I mean, people can get cut through.
Did she say exceedingly weak? Because A+ if she did.
It says, well, that couldn't have been it because he was wearing gloves. Well, I mean, that seems to me to be exceedingly weak as well. I mean, people can get cut through gloves. 1, 2, the only evidence that he was wearing gloves, that the murderer was wearing gloves.
Yeah, I agree with what James said. This isn't circumstantial evidence. This is grasping at straws. Exactly. I completely agree. I don't even think this is circumstantial evidence. Circumstantial evidence, for those, I'm just going to say this, it's evidence that requires at least one inference before it becomes useful, before it can prove guilt. But you need like 20 inferences to get to guilt here.
Gloves was that there was a smear somewhere in the walls. Maybe that's accurate. Maybe he was wearing gloves for a while. I mean, all of it seems extremely forgiving with regard to him and extremely non-forgiving with regard to Bradford. That's really the dichotomy in this case, that everything comes in with regard to Bradford and nothing comes in with regard to Geruso.
I disagree, Your Honor. Both sets of evidence are assessed under 352.
Look at Yakelson's face.
In this case, that everything comes in with regard to Bradford and nothing comes in with regard to Geruso.
I disagree, Your Honor. Both sets of evidence are assessed under 352. There was nothing that was more prejudicial than probative that was admitted against Bradford. It's a cold case, so the evidence is...
The fact that his mother, 40 years later, had some wires that didn't match at all anyway.
What she's talking about, the murder weapon, or one of the murder weapons was supposedly a wire. I didn't remember this until she said it. So there were wires that were supposedly like forensically linked to the murder, and Bradford had wires in his apartment. It sounds stupid because it is, but it's something like that.
And they were 40 years later. No, I don't know. Maybe there was some evidence as to the fact that was there any evidence that she had these pictures on the wall for 40 years?
Well, it was the same. Well, they were able to match 6 of the 8 braids of the wire.
Yeah, but did they know that this wire had been there 40 years before? Did they have any evidence that it was there 40 years before? That seems like very strange evidence.
I love her. Can I just reiterate how... What is it? The K-pop thing? Is it like this? I don't know. Whatever that is.
Strange evidence, but it was sufficient for the jury to convict. And again, going back to EDPA, the question is whether this was clearly unreasonable under Holmes.
That's such a coward thing. It was sufficient for... Everybody knows it was sufficient for the jury to convict because we're here right now. You just don't want to defend the evidence because you can't.
And again, going back to EDPA, the question is whether this was clearly unreasonable under Holmes. And it's not a de novo reweighing of every single bit of evidence.
And again, he was given carte blanche. He was given Cate Blanchett to state the evidence that they had in this case. They gave him the floor and they said, present the evidence. What is the evidence of guilt? And this is what he had. And he's still standing there defending the conviction. How do you sleep at night?
It's not de novo. I mean, I was, having been a trial judge, to me, this was very unusual to not let the jury sort all of this out. Generally, what happens is the prosecution puts on this evidence, the defense, if they have alibi evidence or third-party evidence, they put that on it, then the jury sorts it all out, rather than the judge saying, I'm going to allow the jury to hear this part, but I'm not going to allow the jury to hear that part. Judge Jenkins?
Yeah, I agree with that. It's
I have to say I'm very impressed with all of these justices. I will say that this is also true of what I said about the Georgia Supreme Court that we watched earlier. I've been very impressed with every single justice we've seen so far, even the ones I've disagreed with.
All out, rather than the judge saying, I'm going to allow the jury to hear this part, but I'm not going to allow the jury to hear that part. Judge Jenkins.
Yeah, I agree with that. It's an extraordinary case based on my experience, the way the trial court handled it and the way the prosecutor behaved. But
the way the prosecutor behaved.
I agree with that. It's an extraordinary case based on my experience, the way the trial court handled it and the way the prosecutor behaved. But the bottom line purpose for the rules like the California rule about third-party culpability is to avoid the risk of harassment and confusion. And for the life of me, I don't understand how this evidence that you fought so hard to keep out would have caused any confusion or harassment.
It would have caused confusion as to whether Bradford was guilty. Another way of saying that is it would have called the prosecution's case into question. Some questions are supposed to be raised, and if they can't be answered, you can't convict. That's different from undue confusion.
I don't understand how this evidence that you fought so hard to keep out would have caused any confusion or harassment. Can you shed any light on that?
Well, I think the evidence is very weak. It's very speculative evidence, all told, that either Girosu or Juarez.
Hold on, I need to hear that again. What? I'm sorry, I know I'm repeating this because I'm just too, angry, but...
To hear this part, but I'm not going to allow the jury to hear that part. Judge Jenkins.
Yeah, I agree with that. It's an extraordinary case based on my experience, the way the trial court handled it and the way the prosecutor behaved. But the bottom line purpose for the rules like the California rule about third-party culpability is to avoid the risk of harassment and confusion. And for the life of me, I don't understand how this evidence that you...
Thank you, curiously.
You fought so hard to keep out would have caused any confusion or harassment. Can you shed any light on that?
Well, I think the evidence is very weak. It's very speculative evidence, all told, that either Girosu or Juarez actually perpetrated the crime. That's the standard the defendant needed to meet and could not with this evidence. On the other hand, had that evidence, speculative as it was, been admitted, then it lends itself to all sorts of speculation about, it's like we're going to have a mini trial on whether, how did Juarez's hair look back in 1979, when there's actually no probative evidence tying him to the actual perpetration of the crime. The same is true of Girosu. As counsel mentioned, they had many, many chances to marshal evidence linking Girosu to the actual perpetration of the crime. They could proceed no farther than offering evidence that he was there earlier on the night.
But why wasn't that just given to the jury? And the jury could decide whether or not the evidence by the defense raised a reasonable doubt or not, rather than the judge deciding that it was impossible for the jury to consider this evidence, or it was impermissible for the jury. That's the part that, to me, runs afoul of Holmes, in that the defense was not given the opportunity to completely present its case.
Well, Your Honor, Holmes doesn't allow the defense to put on any evidence that it wants to.
It's not any evidence. It's evidence that was developed during the course of the investigation by the police. I would agree with you if this was some evidence that they had dreamed up, but this is evidence that was developed during the course of the investigation.
And found insufficient to move forward on Girosu. His alibi checks
Also
out.
found insufficient to move forward on Bradford for 35
Okay, this isn't just lag. He's just talking too long.
years too.
Yeah, but then the case it came back from being a cold case, and there was different bits of evidence later. One was the fact that he displayed the same behavior with his 2009 girlfriend, C-Cat, who broke up with him in 2009.
Well, it wasn't the same behavior. He didn't murder her or even attack her, is my understanding.
He did stalk her. He did show up unannounced. all the sort of...
Yeah, and he didn't murder her. How are you this... Not going to say that.
He did stalk her. He did show up unannounced. All the sort of predicate behaviors that he displayed shortly.
What is a predicate behavior? Is a predicate behavior another way of saying things that aren't murder, which is what the defendant was convicted of?
Before he murdered the victim night. Also, his alibi.
You are way over your time. And I would, though, like to ask you the same question I asked your opposing counsel, which is, does it make any difference, should it make any difference in applying Holmes and Hall, the nature of the evidence against Bradford? Does it matter that we're dealing with a totally circumstantial case anyway? And does that mean that the room for the defense to produce a person as to whom there was at least some circumstantial evidence should be larger? I understand that Holmes said no in the opposite direction, but in this direction, does it matter?
I would say that the weight of evidence against Bradford is probably best assessed in this case under the prejudice standard of Brecht, right? There's overwhelming evidence inculpating him. I think the question before this court, though, is whether trial court excluded... Yes?
Do you think this evidence was overwhelming?
It was sufficient for a jury.
I'm sorry. I love these justices so much. Remember, she was the one who asked, tell me all of the evidence. Just tell me all of your evidence. And what did he say? He said he once showed up at an ex-girlfriend's house. And what was the first stupid thing he said? Oh, he was with her that day. Oh, no, the first thing he said was there was a dead body, therefore he's guilty of murder. Oh, they're definitely pissed at the trial judge. There's no question about that.
I think the question before this court, though, is whether trial court excluded... Yes?
Do you think this evidence was over...
I love how these justices are unanimously against this argument. It's a farce and they know it.
This court, though, is whether trial court excluded... Yes?
Do you think this evidence was overwhelming?
It was sufficient for a jury to convict, and I think...
That's not what she asked. Yes or no?
On the basis of it, yeah, I do. Granted, I admit that it's circumstantial evidence, but cold cases, this is kind of how the evidence looks.
Whoa. Did you hear what he just said? He said in cold cases, that's just kind of the way it is, implying that there's a different standard in a cold case as opposed to a regular case, which is objectively wrong. The state has a harder time proving a cold case, absolutely, but that's the state's problem. That doesn't mean you get different evidentiary rules. This is exactly what I was worried about in Wolfenbarger. This is the exact thing that I was worried about. Is the state's going to say, oh, it's been a long time, so we don't know exactly what happened, and the jury would eat it up. Fortunately, that didn't happen, but completely inexcusable.
I admit that it's circumstantial evidence, but cold cases, this is kind of how the evidence looks.
Well, I guess the really interesting question is, if the jury had known that there was somebody in that house for 4 hours that night who was an ex-boyfriend and who had some history of violence and had a cut in his finger afterwards, could that have made a difference as to the...
Objectively, yes. If he says no, I don't like...
their determination that
Bradford
was guilty beyond a reasonable doubt. That's the basic issue. Is that right?
I understand. It is, but not... the basic issue is whether the state appellate court was unreasonably applied Holmes in determining that evidence was insufficient. But in this case, the state appellate court was not clearly and unreasonably applying Holmes at all. For me, it's not even close. The evidence that Girosko was there earlier in that night.
Quote, for me, it's not even close. Well, fortunately, you don't get to decide. We had the wedding invitation, James. That's right. I forgot about that one. The crumpled up wedding invitation, which the state said the only possible explanation is that somebody else did it. There's no way somebody would throw out a wedding invitation. How do you sleep at night? I'm serious. Like, genuinely, how do you sleep at night? He can't possibly not know that this is ridiculous.
For me, it's not even close. The evidence that Girosko was there earlier in that night, and then he left has an alibi. That's solid evidence. He complied with the police investigation.
I think that we consider the alibi at this point, at this juncture.
I think you consider first off, under Hall, you consider the totality of the evidence that's inculpating the third party.
That's not evidence. There's no evidence of the alibi.
Oh, I just want to hear that again. I heard it fine. I just want to hear her say it again.
First off, under Hall, you consider the totality of the evidence that's inculpating the third party.
That's not evidence. There's no evidence of the alibi. There are some descriptions in interviews, but there's no evidence.
That's incorrect, Your Honor. His alibi is supported by his then living girlfriend. She was 100% sure.
Not at the trial. There's no testimony at the trial.
Well, that's because judges serve as gatekeepers.
I know. So what I'm asking is, in determining whether the defense should have been able to put this on, do we consider that there was an alibi evidence that might have weakened the case against Jeruso? Is that something we look at this juncture now? Or that the trial court, or that the California Court of Appeals should have looked at? It didn't, by the way. It never mentioned that.
Well, it didn't mention it doesn't mean it didn't look at it. It reviewed all the evidence against Jeruso because that was in the record before it. And it came to the conclusion, as did the trial court under state law Hall, that this evidence was clearly insufficient under the California Rules of Evidence.
Your time is up. You're way over. So we will give Mr. Elkelson 4 minutes rather than 2. Okay? Because you were 8 minutes over. Thank you.
Thank you, Your Honors. Maybe this is an instance where the less I say, the more important the presentation, because I don't like to point fingers, but Mr. Lewin.
Do it. Point those fingers, Al. By the way, his name is #Al Yockel on Twitter, or Al Yockelson on Twitter. See his name, ALYOCKELSON. So if you want to follow him on Twitter, that is his name.
To point fingers, but Mr. Lewin, the deputy district attorney in this case, has a history.
Did you see this slight head nod?
When the deputy district attorney in this case has. But Mr. Lewin, the deputy district attorney in this case, has a history of bringing these cold cases. He has.
Also, that reminds me, I need to look up his Twitter handle. John Lewin's Twitter handle is @CLDCASE. I'll just share this with you guys real quick, just so you can see. His whole thing is that he is a cold case specialist. I'm a DDA. His handle is @CLDCase. I'm DDA with LA County DA's office, specializing in cold murder cases. So this is his whole identity. I shouldn't say that. It's his thing, is cold cases. Not finding evidence in cold cases, or getting sound convictions in cold cases, just trying cold cases.
A contract.
And getting absolutely clapped by Joe Tacopina in front of the entire world. Those are his two specialties.
Mr. Lewin, the deputy district attorney in this case, has a history of bringing these cold cases. He has a contract with a Dateline who had been in the courtroom. Cases. He has a contract with a Dateline who had been in the courtroom from the in limine proceedings through the end of trial.
He's so sad. He knows he's about to lose.
A contract with a Dateline who had been in the courtroom from the in limine proceedings through the end of trial. And ironically enough, Judge Berzon brought up The Wire. The episode of the Dateline episode was called The Wire.
They had an episode of Dateline called The Wire? That seems like it might confuse some people.
In this case, because it was grabbing headlines. Mr. Lewin likes headlines. Mr. Lewin loves to present.
I want to say this is extraordinarily unusual. Lawyers going after lawyers by name this directly is extraordinarily uncommon, especially before a circuit court of appeal. For him to not be interrupted being this personal is extraordinarily unusual. And the fact that he's not, like I said, the fact that he's not being interrupted by the justices is pretty much a sign that they agree with him and that they're co-signing what he's saying. That might be too strong, but in 99% of the time, this would be entirely inappropriate, but this is the 1%.
Likes headlines. Mr. Lewin loves to present to present love triangle as motive for murder. But what I find most ironic is that I try to imagine myself arguing this case representing Mr. Giarrusso, who, if the court references third volume of the excerpts of record, page 468, a photograph shows him with dark curly hair, to answer the question that counsel tried to sidestep by saying, well, his body.
That is also highly unusual. And again, no interruption. That was a very direct way of saying that. That is the third party, Giarrusso. That is an unusual thing to say, and the fact that there's no pushback whatsoever is telling.
Answer the question that counsel tried to sidestep by saying, well, his body didn't conform with Mr. Rollery's description. And something that has not been mentioned was that Mr. Rollery noticed Mr. Giarrusso's blue Volkswagen parked at the crime scene at 7:30, at 10:30, and saw it driving away at 3 o'clock. Now, I see opposing counsel is shaking his head.
Oh, you are not supposed to show those kinds of reactions. I would be terrible as a trial lawyer for this exact reason. Don't do that. It's considered unprofessional.
Was of the opinion that was too common of a car to have any credibility in identification. But I see Mr. Giarrusso's blue Volkswagen parked at the crime scene.
My very first law job, I actually had my supervisor tell me that I had to stop showing facial expressions during Zoom meetings. She's like, everyone can tell what you're thinking, and that's bad strategically. And she framed it that way because she's like, you can't be mad. I would have been like, fuck, I can't. But she's like, you're tipping your hand by letting the other side know what you're thinking, so it's strategically weak. This was decided a few years ago, so I actually have the decision ready to go. I got fired for facial expressions in Zoom meetings. I'm sorry, I didn't mean to laugh at that, but I respect you. I respect the move.
At 7:30, at 10:30, and saw it driving away at 3 o'clock. Now, I see opposing counsel is shaking his head, and I'm sure he's shaking his head because the trial judge was of the opinion that was too common of a car.
Did you see the way he worked that in? He wasn't prepared for this guy to be shaking his head, and he just worked like an introductory clause based upon the shaking of the head. That is masterpiece level work.
Clock. Now, I see opposing counsel is shaking his head, and I'm sure he's shaking his head because the trial judge was of the opinion that was too common of a car to have any credibility in identification. But what you can't escape is that it was indeed the same car that was there from 7:30 till 3 o'clock in the morning, seen by Mr. Rollery at a time that Mr. Giarrusso himself.
Also, who knows? Was there any evidence that it was a very common car? I was certainly around.
She's asking a question skeptically that is in line with his argument. That was incredible. It sounds like she's disagreeing with him based on the tone of her voice, but she's actually completely agreeing with him.
In the morning, seen by Mr. Rollery at a time that Mr. Giarrusso himself.
Also, I mean, who knows? Was there any evidence that it was a very common car? I was certainly around at the time. There were lots of Beetles around, whether they were light.
I love every one of them.
Common car. I was certainly around at the time. There were lots of Beetles around, whether they were light blue. I don't know.
Not a shred of evidence, Your Honor. I just feel this court has the pulse of.
Did she just wipe her nose on him? Did she just slime out the district attorney's appellate specialist here? Did you just get slimed on camera in 4K?
I just feel this court has the pulse of this case. This court understands how uneven the case was tried, how difficult the court made this case, and how contrary to the teachings of Holmes and Washington and Crane and all of the cases that have come before it that talk about a defendant's right to put on a defense. And he was so unduly and unfairly hampered that I just think a retrial is mandated in this case.
So realistically, do you think this case would be tried again?
In normal circumstances, I would say no, but having dealt with Deputy District Attorney.
Because of how dumb these people are, there's a chance. If they were this is what he's saying. If they were smart, no, but it's them, so yes.
In normal circumstances, I would say no, but having dealt with Deputy District Attorney John Lewin for a year in pre-trial, I don't think that man will ever let anything go.
Which is an admirable characteristic in many ways, but
that's I've never heard anything remotely like that in the Court of Appeals oral argument. The fact that went by without any sort of remark, saying my guy, is remarkable.
In any event, which is an admirable characteristic in many ways, but in any event, thank you both. It's a very, very interesting case, and you've been very helpful, so thank you. Bradford versus Paramo is submitted. Perez Villardo versus Garland is next on the calendar. Oh, and for planning purposes, we'll take a brief break after the next case, after Sanchez-Papoca.
Oh, by the way, pretty much all Ninth Circuit cases are actually.
The board submits it's in their.
So you have Steve Buscemi here arguing the case of Mendoza versus Collins. Or is it Collins? It was Ginger Steve Buscemi, I guess. So I have the opinion ready to go.
Record.
That was written. Who authored it, actually? I should check that. Opinion by Judge Rawlinson. Which one was that?
Wow, there you are.
Oh, Rawlinson was... This one's Rawlinson, right? This is Johnny Rawlinson, I believe. Yeah, the Ninth Circuit YouTube is actually really great. Sometimes when I can't sleep, I'll watch Ninth Circuit YouTube cases. Because I'm a cool person that has a very fulfilling social life. So this is the opinion here. Make it a little bigger. Yeah, James, it's really great. I know there's like a lot of memes about the Ninth Circuit, being like the most liberal court in America, which it probably is. But like 99% of their cases, and 99% of Supreme Court cases have nothing to do with like political affiliation. Oh, this is more recent than I realized, actually. Okay. I need a 1 minute break. I gotta grab some more water. I'm starting to lose my voice. But after that, I'll come back and we'll go through this. I don't know if we'll go through all 70 pages. Good Lord. But okay, yeah, John Antoon, the guy on the right, he's from Florida. But once I get back, we'll go through this opinion, and I assume it's going to be excoriating. So yeah, give me 1 minute and we're back to it. There. Thanks, James. Or Aaron. Yeah, there's a ton of people every time I take a break. I gotta learn how to be a better YouTuber. So this opinion is by John. I think it's Johnny Wallinson. Johnny B. Rollinson. Johnny May Bligney Rollinson. United States Circuit Judge of the Ninth Circuit. Oh, she went to North Carolina A&T. Okay. In 1980, Rollinson and Vivica Monet Woods became the first African American women admitted to practice law in Nevada in 1980. Lord. Okay, here we go. Judge Rollinson, partial concurrence and partial dissent by Judge Antoon. Let's see here. What do we got? Is this just a summary or a... I guess we can read the summary. The panel reversed the district court's denial of Douglas Bradford's habeas petition challenging his first-degree murder conviction and remanded with instructions to grant a conditional writ. This cold case, in quotes, culminated in a conviction 35 years after a murder based entirely on circumstantial evidence after the trial judge excluded exculpatory evidence of another suspect, Joseph Giarrusso, who dined with the victim on the evening of the murder and was the last known person to see her alive. Applying the standard of review required by the Anti-Terrorism and Effective Death Penalty Act of 1996, shout out Bill Clinton, the panel held that in light of Holmes versus South Carolina, the decision of the California Court of Appeal was both contrary to and an unreasonable application of clearly established Supreme Court law. The panel held that the decision was also based on an unreasonable determination of facts. The panel held that the decision was also based on an unreasonable determination of facts. Really says it all. Generally it's rare for appellate courts to contradict a trial court on factual bases. California Court of Appeal did not acknowledge that under Holmes, the application of a state evidentiary rule to exclude defense evidence may violate the federal constitution. Instead, the state court held that because the exclusion was consistent with rules of evidence, there is no constitutional violation. The state court thereby misapprehended the constitutional rule. We kind of talked about that earlier with speedy trials in Georgia, where there's a separate state right and federal right. Second, the California Court of Appeal provided reasons for discounting the jury's evidence, but never weighed its probative value against any risk of harassment, prejudice, or confusion, as required under Holmes. Third, the California Court of Appeal's conclusion that the trial court properly considered that Giudice did not in any way match a witness's physical description of the suspect was an unreasonable determination of the facts, and one that affected the California Court of Appeal's ability to assess the relevance and probative value of the jury's evidence. As California Court of Appeal issued no ruling with respect to prejudice, the panel applied the actual prejudice standard set forth in Brecht and concluded that the errors likely had a substantial and injurious effect on the verdict. Concurring part and dissenting in part, District Judge Tounk agreed with the majority that the state trial court improperly precluded Bradford from introducing evidence regarding Giudice. So everybody agrees that the Giudice evidence should have been introduced, but disagreed with the majority on its determination that the error had substantial and injurious effect or influence in determining the verdict. He would conclude that the error was harmless and affirm denial of relief. So it's this harmless error thing. Everybody agrees that the trial court judge, he messed up. Get Al Yockelson, hashtag or at Al Yockelson on Twitter. Why is my thing not working? What? Is this not? Okay, this is a problem. Why would they make it not editable? I can't work with this. I need to be able to highlight. Sorry, it's a protected file for some inexplicable reason. Oh my god, this is so frustrating. Okay, this is going to have to be good enough. I had that yesterday with the PDF. I basically had a meltdown. Yeah, it's oh my god. Did Puppy wish me a happy birthday? Oh, hey, Anisha. I didn't see you come in. I believe that was Kat, I think. Did you get to the memberships? Puppy just cuddled with me. Jimmy Kimmel has a job now. Yeah, the early 90s were crazy in terms of criminal justice reform. The whole crack baby, supposed crack baby crisis. That's right, factual I did too. Okay, let's see here. Yockelson, Nikhil Cooper. That name sounds familiar. Do I know who that is? That's still at the DOJ. I don't know that person. It sounds familiar for some reason. Brennan. Oh man, that's a red flag. We have Pithy, Rabonta. This quote cold case culminated in conviction 35 years. You guys can see this, right? Yeah. After a murder based entirely on circumstantial evidence. Sorry, setting up my little thing here. I need to get a second widescreen monitor so I can do this better. I have one like regular size and one widescreen. Okay. based entirely on circumstantial evidence. Unfortunately, the trial judge erroneously excluded powerful exculpatory evidence of another viable suspect, namely the individual who dined with the victim on the evening of the murder and was the last known person to see her alive. I'm really interested to see the harmless error opinion. Under the compelling facts of this case, we are persuaded this is one of the rare instances where when the state court's determination that there was no constitutional error in excluding third-party evidence was unreasonable. So you super fucked up, and John Lewin is super bad. In 2014, Douglas Bradford was convicted of the 1979 murder. I didn't realize that those were the years. That's wild. So I imagine a blue Volkswagen was particularly rare in 1979. On August 30th, 1979 at 3 a.m., Knight's neighbor, Richard Valeri, was awakened by a scream. He looked through the window, saw a light go out at Knight's home, and noticed that the gate to the property was wide open. Moments later, Valeri saw a guy walking across the street and decided to check on Knight. When Knight failed to respond, Valeri called the police. Responding officers discovered Knight's body lying on a bed with multiple stab wounds and a garrote beneath her body. Next to Knight's body was a broken clasp to a necklace and a gold medallion, but the rest of the necklace was never found. My mom had a yellow bug in 1968 that my dad. Based on those 1960s bugs, it probably was fine. Rotating vertically, yeah, probably. An invitation for Knight's sister's wedding was seen crumpled up in or near a trash can. Like, remember, this is what the state's appellate attorney said was the evidence: the necklace and the invitation to the wedding. So this is like, what's about to follow is the takedown. Ooh, I'm about to sneeze. Okay. Valeri described the man he saw walking away as a possible white male, approximately 5'9", with curly afro-type dark hair, wearing a beige jacket and pants, and carrying a small black unknown-type bag. With this description, officers surveyed the area and discovered Gerardo Juarez, approximately a half-mile away. So there's a third dude? Okay. Officers described Juarez as extremely nervous and very jittery during their conversation. I mean, that's reasonable. You're being questioned in a murder case. Wait, what? They noticed what appeared to be fresh, moist blood on Juarez's jacket and abrasion on his knuckles. When asked about the blood, Juarez explained that he had been mad and hit a telephone pole. It was a device used to accomplish strangulation. I like the wire. The crumple zone back. Yeah, exactly. The wire. I forgot about the wire. I love the wire. As questioning continued, other officers transported Valeri to the scene. Upon his arrival? What did I say? Arrival? He crashed the back while backing up, and once more smashed the front. Oh, he's a 2-foot driver. Interesting. How did your mom feel about that? Upon his arrival, Valeri faced Juarez and expressed uncertainty about whether Juarez was the person he observed. But once officers directed Juarez to turn his back, Valeri immediately said, "That looks like the guy." He added that Juarez's jacket color, pants color, and hair were, quote, very similar to that. I'm sure she was. Very similar to that of the person he saw leaving the location. Juarez was taken to the station where a criminalist took his jacket to compare stains to the blood of the crime scene. The criminalist ultimately determined that the spots and stains on the clothing were not blood. 24 years later, was he one of their informants? I'm not sure. 24 years later, Valeri recalled that upon reflection immediately afterward, he realized that Juarez was too small to be the person he saw running away, that the only similarity was his coat and perhaps the look of his general look of his hair. This is what happens when 24 years pass. Your memory changes to fit what you believe to be true. Memory is incredibly fragile, which is something that courts have been slow to recognize. There have been studies. That's actually something one of my professors at USC studied quite a bit, was the extent to which memory is susceptible to suggestion. For instance, if you ask if you ask a witness at what speed did the vehicle come into contact with the other vehicle, and then you ask them, another group, at what speed did the vehicle crash into the other vehicle, you'll get two completely different average estimates of speed just based on the form of the question. Memory is extremely fragile, is my point. Larry emphasized that he never saw the face of the person running away and therefore would not be able to conclusively identify this person. During the same follow-up interview, Larry said that he recalled the events surrounding Knight's murder like it was yesterday. Everybody says that. Larry related that after he'd called the police on the night of the murder, he waited at his window and noticed at a nearby intersection the same beat-up light blue Volkswagen that had been parked outside Knight's home before he went to bed. Yeah, exactly. I never rely on someone who witnessed something or someone ever on video first. It's not good. Yeah, not good 24 minutes after usually. Yeah, and also the other thing is like police lineups, like identification. Yeah, if you it's something like if the person doesn't identify the suspect in the first like fraction of a second, the reliability of the identification falls like by an incredible. I don't remember the statistics exactly, but it's like if the identification happens in the first half second, it's reliable, and if it doesn't, it's not. Yeah, completely agree with James. Erlinda, Valeria's wife, said that Knight told her she was having a friend over for dinner on the night of the murder. According to Erlinda, Knight stated that this friend had previously punched her in the mouth, but the incident had been a misunderstanding. On the evening of the murder, between 6 and 7, Knight came to the Valeria's home to borrow cooking utensils, at which time Erlinda looked out her rear window and saw the man she assumed Knight was entertaining. She described the man as white, a little over the night on the heavy side, with dark hair that was balding in front. During an interview with detectives, Girusso stated that he had a dinner date with Knight hours before she was murdered. So this seems like multiple people are placing Girusso at the scene of the murder. When I worked at a bank, we had to take class about robberies, and they did a mock hold-up. Even though we knew we would have to give descriptions, we also, it's really crazy once you like get objective evidence of memory, like how fragile it is. People think that they remember, but it doesn't really work that way. It's shown that even if like you have a conversation, if you witness something and you have a conversation with just a random person, you're at the accuracy of your memory plummets between the conversation with a random person and a conversation with a person who asks you to recount your memory. He related that he arrived at Knight's home at approximately 8:30 and left for his girlfriend's home at approximately 11:50. That girlfriend's not going to be happy. So Girusso was there from 8:30 to 11:50. Girusso informed detectives that he and Knight had lived together for more than 2 years, broke up, but remained, quote, very, very, very close friends. Netflix and chill before Netflix. One of my professors at UT Texas did some of the research proving, When asked if he had intercourse with her the night of the murder, he replied, never. I have not made love to Lynn Knight for at least 3 years. 2.5. Upon learning of Knight's murder, Girusso described himself as distraught. He also offered to do whatever he could to aid detectives in their investigation and consented to a full search of his car. During the interview, Girusso indicated that he knew what a garrote was, describing a garrote as a piano wire to strangle somebody with. Although he denied ever making a garrote, he explained that if he were to make one, I would make one big enough to loop around the individual's neck, whether it be 2 feet or, quote, 18 inches. By contrast, Bradford was 6'1", 155 pounds, and 27, had a full head of brown hair. Girusso is 5'9", 164, and 31 years old, and was balding. So the physical description absolutely, this Girusso, it absolutely does not fit Bradford. Full head of brown hair, 6'1". Yeah. Girusso also told detectives that he had served in the military as an electronics technician during the Vietnam War. When detectives, it's crazy that we're talking about a Vietnam veteran and a 2014 conviction based on something that happened in the 70s. Not that we shouldn't trust absolutely, memories fade. And the state bears the burden of, I know you know this, the state bears the burden of overcoming the fact that it's been 24 years. It seems like it didn't in this case. When detectives interviewed Giarrusso's girlfriend, Collado, she told detectives that while Giarrusso had his own apartment, he frequently stayed with her. Girl. Marsha. My girl. Okay. She needed a friend, clearly, because I hate the state press witnesses, but I give them, yeah, waterbed. Oh, Giarrusso. Waterbeds. Waterbeds. You'll either have a great night's sleep or your entire house will flood. She responded the night of the murder. Giarrusso returned from Knight's house sometime after 11. So there's multiple. So there's corroborating evidence that Giarrusso was there until 11. That corroborates Giarrusso's own testimony, and then the car, the blue Volkswagen. At least it's not the Waffle House. Matthew, the thing about a Waffle House is the eyes of crackheads are basically stars watching you. They discussed his evening with Knight and eventually went to sleep on her waterbed. She assured detectives. I feel like her using waterbed is just to emphasize the passage of time. She assured detectives that Giarrusso did not leave the house until the next morning, explained that she's a light sleeper and would have noticed even the slightest movement on the waterbed. Both Giarrusso and Collado agreed to a polygraph test. The polygraph results were inconclusive of Giarrusso, but reflected that Collado was not lying on any of the questions. Long after Giarrusso passed away in 1994, Collado maintained she was 100% certain of the facts regarding his whereabouts. So Giarrusso died precisely 20 years before the conviction. Wild. It makes Tisha Bradford. Very ceilings. Bradford's name came up in several interviews with Knight's close associations. As Knight told him about trouble with any of the men in her life, Knight's boyfriend of 5 weeks responded that Knight thought that Doug was getting too serious. And the same question was asked of Knight's good friend, Judy Bradley. She stated that a year or so prior, Knight told her about a man named Doug Bradford who was serious. Knight's friend Mary Coburn knew of 8 men Knight was dating. Yeah, get that roster going, Knight. But specifically described Bradford as sending her roses, and the roses would appear on the table in her apartment. Coburn also recalled Bradford buying Knight a necklace. Giarrusso recalled trouble between Bradford and Knight, and in particular described an incident in which Bradford showed up. I thought I was going to say shoved her. Showed up at Knight's house and found her with another man. He reported that Bradford whipped the screen door off, made a very horrendous scene, and hurts Lynn's emotional feelings very, very much to the point she called Giarrusso up. I did have a water back when I was pregnant back in 2003, and it was amazing. I've laid in a waterbed before. It's fantastic. Hey, Aaron, get yourself one. Treat yourself. Giarrusso said Bradford left after 20 or 30 minutes of carrying on, calling her a slut, a tramp, and accusing her of giving him an STD. But not murdering her, which is really critical. Knight's co-worker, Rita Retort. Her name's Rita Retort. That's fucking incredible. Rita Retort also mentioned Bradford, recalling that Knight told Bradford she did not want him to come over, again unexpectedly, because it was embarrassing to her that he had seen her with another man. Fair. Larry likewise recalled an incident in which Bradford had found Knight in her apartment entertaining another boyfriend and angrily left Knight's apartment. In the heat of them in the winter, yeah. Yeah, I slept in the main winter. It's fantastic. When Larry later asked her about the incident, Knight just laughed it off, and she expressed no concern about the incident. Detective Hilton. This case is riddled with holes. Detective Hilton interviewed Bradford, who maintained that he was sailing a boat the night of the murder from 10 p.m. to around 1:30 a.m. I believe in convicting anybody who owns a boat, so in that sense, I'm okay with it. This is a working boat, like a lobster boat. When asked by Detective Hilton to show him the boat, Bradford refused. Fair. Bradford said he dated Knight for several months until they decided in early June 79 to no longer see each other. I can't believe we're talking about a 1979 case. He acknowledged that he had gone to Knight's home to return some items to her the day after they broke up and saw a mail there, which caused him to become angry and make several unkind statements. So he's, because of the implication, Excellent comment, James. This is actually makes me kind of militates in favor of innocence. He's admitting admitting that, a version of what happened. He said the bad things. He was there. He said unkind things. So this seems to corroborate the other testimony, which doesn't make me think he's guilty. So this is all made from witness testimony. Yeah. Back in his 20, lived in a basement apartment. Yeah, that makes it. That does make a difference. Bradford identified this video last time he saw Knight. Our colleague in dissent notes that Giarrusso only relayed what Knight told him. However, it is undisputed that Giarrusso reported this incident to detectives. Little judge-on-judge violence there. Detectives later showed Valeri's brother, who lived in the garage adjoining Knight's home. Wait, what? Detectives later showed Valeri's brother, who lived in the garage adjoining Knight's home, a photograph of Bradford and asked when he last saw him. The brother reported to the police that he saw Bradford approximately 1 month prior, walking on the sidewalk in front of her apartment. The approximate date of July is not necessarily inconsistent with Bradford's statement that he last visited Knight in June. That's actually pretty fair. I mean, Bradford said June, the brother said July, 34 years ago. It seems like all the Bradford's statements are being corroborated here, at least reasonably so. June versus July, and several decades apart, is seems reasonable to me. Detectives suspended the murder investigation in 1982 for lack of evidence. After the case was reopened in 2000, the police discovered new evidence, including Bradford's stalking of a girlfriend following their 2009 breakup and picture-hanging wire found at Bradford's home 28 years after the murder of the same class as the wire used to create the garrote that was found beneath Knight after the murder. So Bradford had pictures hanging in his apartment, and he's apparently stalked but did not murder another woman 30 years later. As the government concedes the case against Bradford was entirely circumstantial, no eyewitness ID, fingerprints, DNA evidence, video surveillance, or confession. The state trial court's exclusion of third-party culpability evidence. Before trial, okay, so let me just remind you guys, everything that we just said about Giarrusso was not introduced at trial. All of that stuff. That third-party culpability evidence was not admitted into trial. And even if you think that, it's not convincing, it's still certainly fairly compelling, I would think. State trial court's exclusion. Before trial, the prosecution moved to exclude evidence related to Giarrusso and Juarez due to insufficient connection to the murder. Think about it. That just drives me crazy. If you're a prosecutor and you're proceeding in good faith as opposed to trying to get a conviction, would you want the evidence of Giarrusso excluded if you want a fair trial? If you believe it's beyond a reasonable doubt, I'm so ashamed. James, come on. I think you know the answer to that question. The prosecution moved to exclude evidence. This motion encompassed evidence of Giarrusso's presence at Knight's home on the night of the murder, citing People v. Hall. In Bank. The prosecution argued that the evidence failed to raise a reasonable doubt as to petitioner's guilt. That is for the jury to decide. The state trial court agreed with the prosecution and excluded the evidence on the basis there was nothing to connect Giarrusso there at the time of the perpetration of the crime. That is batshit crazy. Is no more speaking gigs for the California Bar Association? Possibly. Following this ruling and during his opening statement at trial, the prosecution declared, this is John Lewin, now what's very clear is that for several nights leading up to the murder, there was one night when Lynn was home by herself. One night only, and that was the night that she was murdered. He knows that's not true. He knows that's not true. Everybody agrees. Everybody agrees that Giarrusso was there that night. Giarrusso agrees. Giarrusso's girlfriend agrees. The neighbor agrees. Everybody agrees. Giarrusso was there that night. The statement, now what's very clear is that for several nights leading up to the murder, there was one night when Lynn was home by herself, one night only. That was the night that she was murdered. That is objectively false, and he knows that it's false. It's entirely bad faith. He's trying to get a cold case conviction to bolster his reputation by saying things that are entirely demonstrably false. This statement would have been directly contradicted if evidence regarding Jeruso had not been excluded. Bradford challenged the prosecution's statement as misleading the jury. Bradford argued that it was important for the jury to know that Knight was not alone on the night of the murder. The prosecution responded that who Knight had dinner with that evening was irrelevant. It contended that the court would find this fact relevant. The jury needed instruction that the person that Lynn Knight had dinner with is not a suspect in this case, and you are not to draw any inferences that he was involved in the homicide. I'm so mad that I want to yell. John Lewin is a fucking scumbag for this. He belongs in prison. It's unconscionable that you would even think of this. If you would even think of saying this, you have no business being a prosecutor. The last person to see her alive is irrelevant. The last person to see the victim alive is irrelevant. That's fucking insane. Probably got a promotion. The court determined the prosecution's statement was not inaccurate because Knight was alone during the relevant time period. The night of the murder is apparently the relevant time period. Not the relevant time period. Ultimately, a jury convicted Bradford of first-degree murder and he was sentenced to 26 years to life. The only thing that I can think of is Bradford's alibi is kind of weird, but people go sailing at weird times. It's based on like winds. When I grew up in Maine, and I was on this swim team, Division I swimmer here, by the way. In college, my teammate, who's a state champion swimmer, he would go. The only time you can surf in Maine is during winter storms. So if there's like a blizzard in Maine in like January, the ocean gets like big enough to go surfing. So people will go surfing at like 3 o'clock in the morning in January in Maine when it's like negative 15 degrees. People that do ocean stuff are weird. So somebody going sailing in the middle of the night is not entirely unusual or suspicious. It's weird, but that doesn't mean it's not true. Both people are weird, exactly, James. Yeah, completely agree with you. Okay. California Court of Appeal affirmed Bradford's conviction. California Court of Appeal, by the way, undefeated record. Actually, before I left my job in Big Law, I won an appeal that I had forgotten about. I'd written a brief like months before, and I filed it, and I had completely forgotten the case existed. And then I got notice of the decision. They decided they didn't need oral argument. And I just got a notification by email that I had won the case. That was a fun one. The appellate court concluded that the trial court did not abuse its discretion in excluding evidence related to Juarez. Juarez I can understand, because his proximity to the murder scene meant that Juarez had at most the opportunity to commit the crime. That doesn't make sense, which was not sufficient to constitute third-party culpability evidence required to be presented to the jury at all. Remember that guy who stayed in his boat during that hurricane in Florida? I don't remember that one. The appellate court remarked that the only other evidence linking Juarez to the murder was Valeri's statement that... That's good, though. The appellate court remarked that the only other evidence linking Juarez to the murder was Valeri's statement that Juarez possibly could have been the person leaving Knight's apartment. The appellate court deemed O'Leary's identification unreliable because it was based entirely upon seeing him from behind and was later recanted. Yeah, decades later, you're relying upon the statement decades later as opposed to the statement that's relatively contemporaneous. I generally believe you should trust recantations, but like, go with the one at the time. The court added that even if O'Leary's identification could have been construed as linking Juarez to the active perpetration of the crime, it had such minimal probative value that the trial court did not abuse discretion in excluding it under California Rule of Evidence 352, given the absence of any other evidence connecting Juarez to Knight's murder. If I'd been trying this case, I would have had a fucking stroke. It's not, but it is anything mental health when a lawyer steals from... Yeah, I agree with that. I actually... Trust funds and like that sort of thing is something I would have worked on. I did a lot of receivership work, fiduciaries. My actual Ninth Circuit case involved a fiduciary. The Court of Appeal also concluded the trial court did not err in excluding third-party culpability evidence for the Giarrusso, because it reflects at best that Giarrusso had the opportunity to commit Knight's murder, but opportunity is not enough. That is fucking stupid. I think that's right, Aaron. I'm not sure, though. Like, it reflects at best that he had the opportunity to commit her murder. Like, no, but he knew her. Like, it's not just like a lot of people had the opportunity, but he was like physically with her. He was the last to see her alive. That's not the same as the mere opportunity. Lieutenant Dan. I got new leg. You got new leg. Okay, the Court of Appeal determined that the trial court properly considered that Giarrusso not in any way matched the neighbor's physical description of the person that the neighbor saw leaving Knight's apartment. As discussed, the record reflected that Giarrusso's hair matched Valeri's description of the suspect, his height matched one of Valeri's descriptions, and Erlinda's description of the person she observed dining with Knight. This is like subtly, but also very directly. This is incredibly shady of the Ninth Circuit. This is judge speak for you are a fucking idiot and you don't even deserve to sit on the bench. And how fucking dare you? You're so stupid. I can't believe you remember to breathe when you wake up in the morning. That is what that is. That footnote was just like, that was Ether by Nas. That was Not Like Us by Kendrick. That was aggressive, but in judge speak. Oh yeah, height's incredibly difficult to estimate. In addition, the court concluded Giarrusso's knowledge of the side entrance to Knight's apartment, his knowledge of what a garage was, that he had bandaged on his thumb a few days after the murder, that he once hit... Wait, Giarrusso's the one that hit her. I thought they were saying Bradford was the one that hit her. Damn. That's even worse. I thought they were saying Bradford hit her. I need to restart that sentence. In addition, the court concluded that Giarrusso's knowledge of the side entrance to Knight's apartment, his knowledge of what a garage was, that he had a bandage on his thumb a few days after the murder, that he once hit Knight while they dated, did not forge a sufficiently strong link between Giarrusso and Knight's murder to constitute third-party culpable evidence. Under all, that was the shadiest sentence I have ever read. Good Lord. Actually, this is an interesting thing I want to talk about. So lawyers can't do math except for me because I have a brain. But statistical probability is something that comes up somewhat in these sorts of cases. And this was an example they used. This came up in the OJ case. In OJ, apparently, I don't know if this is true, but it was told me by the professor, they conflated the difference between whether somebody who has abused their significant other is the person who murdered the significant other with, if the significant other has been murdered, that murder was committed by the spouse or significant other who has previously abused them. Those are subtly two different things. And apparently in the OJ case, those things were conflated. Ultimately, the state appellate court held that because the trial court's exclusion of the evidence concerning Giarrusso is consistent with the rules of evidence, there is no constitutional violation. This is a step above eating chicken entrails. They sure did do that. I was pissed. Okay, I didn't know that. I actually don't know anything about OJ because I liked doing new stuff and new cases that don't get enough attention. That OJ case is like as far not that as you can get. Bradford filed a petition for writ in the United States District Court for the Central District of California. That is Los Angeles. The Southern District is San Diego. The Eastern District is Sacramento. The Northern District is like San Francisco. Asserting that the state courts unreasonably applied Holmes versus South Carolina. That's crazy. You're citing to a 2006... Nope, not you. Which one's that? Is that Q? I don't use that one that much often. I was in college with my roommate. I remember watching the Bronco chase. When I was in DC, there was a cover band called White Ford Bronco, and they did 90s cover songs. My boy John dated the lead singer of White Ford Bronco. The magistrate judge, we were bartender bros. I think he took the fall for his son. That could be. I don't know anything about the case. The magistrate judge concluded that the exclusion of third-party culpability evidence relating to Juarez and Giruso did not involve an unreasonable application of clearly established federal law and agreed with the state appellate court's reasoning. The magistrate judge emphasized that evidence of opportunity to commit the offense must be coupled with substantial evidence tending to directly connect that person with the actual commission of the offense. That's actually kind of interesting because, like, there wasn't any evidence. To be fair, there wasn't any evidence, hey puppy, that Giarrusso did it. Any substantial evidence that he did it, but there also wasn't any substantial evidence that Bradford did it. So the magistrate might have actually been, like, technically correct, which is kind of funny. The district court adopted the magistrate judge's report and recommendation, denied his petition, and dismissed the action of prejudice. On the freeway and had to pull over as in our school that night and been in studio for 3 weeks. Yeah. The district court granted a certificate of appealability on a single issue, whether the California court's rejection of petitional challenge to the exclusion of third-party culpability evidence regarding Giarrusso was contrary to or involved in unreasonable application of clearly established federal law, as determined by the Supreme Court. Bradford filed a timely appeal to this court. We reviewed de novo a district. See, this is something I hate about Georgia. Georgia cases don't, like, explicitly state this that frequently. In California or the Ninth Circuit, you will get those explicit statements of the standard of review. When I was writing Sledge's brief, the appellate brief that we just filed, it was really hard to find, like, statements of the standard of review, and I kind of had to, like, piece them together from different cases. It was really difficult to do. That was one of the. I spent more time on standard of review and preservation of error than I did on the substance of the appeal. And I actually expect the state's opposition to focus on appealability and standard of review. I don't think the state will contest the substance of it because they know they're wrong. Because Bradford filed his habeas petition after the 96 effective date of the AEDPA, standard governs our review. Federal court may only grant habeas corpus relief when the state court's ruling was contrary to or involved in unreasonable application of clearly established federal law, as determined. Wait, what was that? What did I say? Now, Bradford's request is saying this, yeah. By the Supreme Court of the United States, or was based on unreasonable determination of the facts in light of the evidence presented in the state court proceeding. That's a pretty narrow standard. I'm starting to think these 90s crime bills weren't very good. Contrary to, involved in unreasonable application of clearly established federal law. Mention of the facts. I do kind of like to. It gives the appellate court some leeway with respect to the facts. Although we give deference to state court decision, deference does not equate to abdication. That is a fucking good sentence. I'm going to steal that. I'm serious. I'm going to steal that. AEDPA requires that we treat the decisions of state courts with deference, but does not insulate them totally from our review when federal constitutional rights are implicated. We view the last reasoned decision of state courts. In this case, the last reasoned decision is the California Court of Appeal decision on direct appeal. Unreasonable application of clearly established federal law. There's 28 USC, that is procedural and generally jurisdictional sections. Clearly established law refers to the governing legal principle or principle set forth by the Supreme Court at the time the state court renders its decision. My first week of law school, we were in civil procedure. We were learning about federal jurisdiction, and there are two main sections, which is 28 USC 1331 and 1332. 1331 is federal question, meaning it's a matter of federal law. 1332 is diversity jurisdiction, meaning it's like between people of different states. And my professor called and she's like, which one is 1331? And I couldn't remember. And I got the wrong one. I got that question wrong. I remember every single question I got wrong in law school. A state court's decision is contrary to clearly established federal law if the state court applies a rule that contradicts governing law set forth in Supreme Court cases, or if the state court confronts a set of facts that are materially indistinguishable from a decision of the Supreme Court nevertheless arrives. That's a little different from Supreme Court precedent. State court decision is on a reasonable application of clearly established federal. Wait till you hear about the Insurrection Act. Now you remember them? Yeah, no. Actually, my first day in that class in civil procedure, the professor's name was Rothmeyer. She was incredibly terrifying. You know, Legally Blonde, when they cold call Elle Woods and she doesn't know the answer, and the judge like goes, or the professor goes to the next person. What this professor did, she made the person silently read the case that he was supposed to read in front of the entire class while everybody sat silent and waited for him to give an answer. We sat for 15 minutes. We all sat silently and waited for this motherfucker to read the case and give an answer. And he still got it wrong. It was the most awkward shit I've ever experienced in my entire life. One of my proudest moments in law school was actually in that class where she cold called me for 45 minutes straight. And then at the end, she said, I think it's time to call in somebody else. And I thought it had been like 5 minutes, but then everyone after was like, oh man, you did a great job. That was like 45 minutes. And I had no idea. She was terrifying. I'm still scared of that woman. Actually, I have her book here. Let me see if I can find her book real quick. I could not find her book. We'll get to that next time. My criminal and civil procedure law professor lectured the class once about the fact that none of us knew the term red herring. My criminal professor is named Jody Armour, and he actually, so his father was an inmate in Ohio, and this was like during the 60s, and his father had married, he's black, and his father had married a white woman. And so he got arrested. The father got arrested, and he was charged with, I don't know, like, he got like 25 years for having marijuana. There's no evidence that he had marijuana. But his father, he learned the law while he was in prison and actually won I think it was a Fourth Circuit in Ohio. I can't remember what circuit it is. Yeah, Fifth Circuit? It might be Fifth Circuit. So his father won the Fifth Circuit case, an appellate case, based on what he had taught himself in prison. And he used a typewriter to write his appeal to the appellate court. And now Jody Armour, the professor at USC, he actually teaches his father's case in the criminal law course that he teaches. It's really cool. And he actually has, I believe he has his father's typewriter, the one that he wrote the appeal on. Really cool guy. Incredibly nice house. In this case, the clearly established federal law concerns third-party culpability evidence. Third-party culpability evidence is some of the most powerful evidence a criminal defendant can offer the jury. If believed, reasonable doubt is almost a foregone conclusion. Evidence. This is a really well-written brief. She's a really good writer. Exclusion of such evidence is often a considerable blow to the defense. I really like her writing. She's really good. I didn't make it far enough to take the LSAT, but to take the NYPD exam and pass that. Hey, man. I'm sorry, I'm just thinking of Viverito failing out of 2 different police academies. I shouldn't be saying this stuff, but I took the LSAT right after college. I got like a 159 because I was hungover. My uncle's lawyer for the Hells Angels when they come to Daytona Bike Week. I'm struggling for some other. Oh, that's awesome. I was when I was a bartender in DC, we had Police Week, and all like the police from all over the country come, and they kept getting fucking blackout drunk and losing their guns. We had like a bunch of guns in our office, and then the cops would come back, be like, "Hey, I think I left my gun here last night." I'm like, "Is it the Glock? Is it the Sig? What? You're gonna need to be more specific, my guy, because we got too many guns in here." Oh my goodness. And I was worried, like, what if I give him the wrong gun and he goes out and shoots somebody? Like, am I liable? Okay. Oh my goodness. All I can get is the Georgia Gang Investigator certification. I really want to take one of their courses just to be a dick about it. In Holmes, the Supreme Court considered when the exclusion of third-party culpability evidence violates a criminal defendant's constitutional right to present defense. Holmes addressed an appeal from a defendant who'd been convicted of murder related crimes. At trial, the prosecution relied heavily on forensic evidence. The defendant attempted to refute that the evidence. No, I want to get back to this case. I want to hear about this case. Still summarizing Holmes, rather. In light of Holmes, the decision of the California Court of Appeal was both contrary to and an unreasonable application of clearly established Supreme Court law. The court also unreasonably determined the facts. First, the court did not acknowledge that under Holmes, the application of a state evidentiary rule to exclude defense evidence may violate the federal constitution. Oh, hey, Mary. No problem. And instead, the court held that because the exclusion was consistent with the rules of evidence, there was no constitutional violation. The state court thereby misapprehended the constitutional rule. Second, the Court of Appeal provided reason for discounting the Giarrusso evidence, but never weighed its probative value against any risk of harassment, prejudice, or confusion. This is like you were wrong about everything. Specifically, the Court of Appeal decided that Giarrusso's presence in Knight's apartment on the night of the murder, his knowledge of the side entrance to Knight's apartment, his knowledge of what a garrote was, as well as the fact that he had a bandage on his thumb, and police spoke with him a few days after the crime, and had once hit Knight while they dated, were facts that did not forge a greater link between Giarrusso and Knight's murder than the link that would be formed from evidence of opportunity alone. A new Viverito applied to NYPD, but it was never explained why she was a cop in Georgia. Yeah, she failed out of. Actually, hold on. I might have her. It's the first one or the second one? She was. Can you guys see this? Actually, I can't tell. Yeah, you guys can see this. She was Atlanta Police March. State of New York Police Department, July 14 till December 14, and then she was Atlanta PD, March 15 to August 16. But she failed both. This is one of the shadiest things I've ever read. This is the shadiest sentence in judge speech that you will ever see. This is like her listing all of the ways in which it is a greater link, and then saying the appellate court found this. That assessment is unreasonable. The prior violence bandage presence in the apartment, rather than simply the opportunity to be there, knowledge of relevant circumstances taken together add up to more than evidence of opportunity alone. Rather than allowing the jury to weigh the evidence, the Court of Appeal determined for itself that these facts do not constitute sufficient direct or circumstantial evidence linking Giarrusso to the actual perpetration of the crime. Again, this case is entirely circumstantial. It's 35 years old. So, like, all the evidence is circumstantial. Why exclude this evidence? The Court of Appeal also provided explanations for Giarrusso's knowledge of the side entrance into garrote, as well as the bandage on his hand. Tanner, colleague in dissent, in the context of determining prejudice, does the same regarding Giarrusso's knowledge of garrote and his bandaged thumb. But of course, assessing such explanations is a question for the jury, not judges. Nevertheless, it is interesting to note that Giarrusso had a cut on his thumb when a knife was used to murder Knight, and Bradford had no cut on his hands at all. This might be my favorite Ninth Circuit justice. She's fucking fantastic. This is incredibly well written. I might need to take this up another time. I feel like my birthday party's about to start. We're gonna have to pick this up tomorrow. I gotta go now. I'm sorry. I turned the R. Thanks, Mary. I gather you guys won't be too angry about this one, but we'll finish this tomorrow. I'll do like a yeah. Oh, thank you, Matthew. James. Okay. Oh yeah. Okay. Thanks, everybody. I'll finish this tomorrow though. This is I haven't read this opinion in full. It's really well written. I really like it. I'm sorry, Aaron. Next time. Next year, exactly. Okay, I gotta let her know. Thank you everybody for watching, and we'll definitely pick this up tomorrow. I really like this opinion, and I'm only 22 out of 70 pages through. Thanks, Aaron. No, I appreciate everybody. But I'm gonna end it here. Walk the dog. Start the birthday party. But thanks everybody. Sorry for the abrupt ending. Yeah, really appreciate it. Everybody.